The meeting will come to order. Thank you all for coming to this organizational meeting of the Oversight Subcommittee for the 114th Congress. I'd like to keep this organizational meeting brief so that we can move right along to begin this morning's hearing. This meeting is open to the public, and there will be an official transcript of the proceedings. We're going to have a good mix of returning and new members of the subcommittee during this Congress, and I'm honored to be able to serve as the chairman. I'd like to introduce our members, some of whom are on their way, and I know that that is the same thing with Mr. Lewis's members. Representative Marchant of Texas, Representative Kelly of Pennsylvania, Representative Meehan of Pennsylvania, Representative Holding of North Carolina, Representative Smith of Missouri, and Representative Nome of South Dakota. I'd like to also introduce our subcommittee staff, who I'd like to ask to stand when I call their names. Mark Epley, Nicole Foltz, Amanda Neely, and Jennifer Acuna. On my left, I have the great honor of serving alongside a man of an incredible reputation from the work that he did before coming to Congress, and now it's a great honor for me to serve with Mr. Lewis of Georgia. And Mr. Lewis, as our ranking member, I look forward to working with you toward a good end all the way around, and wanted to invite you to introduce your members and staff if you so choose.
Well, thank you, Mr. Chairman. I'm very pleased to serve as the Oversight Subcommittee ranking member again in the 114th Congress. I look forward to working with you, Mr. Chairman, and all of the members of the Oversight Subcommittee. I want to thank you for your great and outstanding leadership. Mr. Chairman, I'm interested in a few key areas: IRS, taxpayer service, enforcement, and tax fraud. And I hope to continue to operate in a bipartisan fashion, as is the subcommittee's tradition. The subcommittee Democrats, Joe Crowley, New York, Charles Ranger, New York, and Lloyd Doggett, Texas. Thank you, Lloyd, for being here. Mr. Chairman, in particular, I want to welcome Representative Doggett to the subcommittee. I worked with Mr. Doggett for many years on the Human Resources Subcommittee, where he is ranking member, and I look forward to working with him on oversight too. Again, I welcome each and every one of the new and returning Republicans to the subcommittee. I look forward to working with all of you in the upcoming Congress. Now, the Democratic subcommittee staff include Carrie McAfee as staff director. Carrie, will you stand? Michael Collins. Michael, you here? And Jamila Thompson. Jamila is absent today. And now, Mr. Chairman, I want to recognize Mr. Charles Ranger, who just came in. Welcome, Mr. Ranger.
Thank you.
And I yield back.
Thank you. We're also joined by Mr. Johnson of Texas, who chairs the Social Security Subcommittee, who's joining us for this subject matter today, and he's always welcome, of course. On a procedural note, as in years past, the subcommittee will operate under the same rules as the full committee. Chairman and ranking member or their designees will each make an opening statement before we hear from witnesses, and other members may submit written statements for the record. The chair intends to require both witnesses and members to adhere to the 5-minute rule for testimony and questioning, and if needed, we can proceed with a second round of questions. And on occasion, other members of the full committee or members who are not on the committee at all choose and reach out, they can join us as well. Are there any questions as it relates to these process? Seeing no questions, I want to thank our members for attending this meeting today and look forward to working with all of you in the months ahead. And with that, the organizational meeting stands adjourned, and we'll move into our hearing on protecting small businesses from IRS abuse. Now the hearing will come to order. And welcome to the Oversight Subcommittee hearing on protecting small businesses from IRS abuse with IRS Commissioner John Koskinen on the first panel. And on the second panel, we'll hear from Mr. Sowers, Mr. Hirsch, and Mr. Clyde, all small businesses who have had their assets seized by the IRS. In addition, we'll hear from Mr. Johnson, a resident expert in this area of the law. We're here to examine the IRS's use and abuse of its civil asset forfeiture authority. And what is this exactly? Well, under current law, federal agencies like the IRS can seize people's assets without any proof of wrongdoing. Now, this law was supposed to stop criminal enterprises and recover ill-gotten gains, but the IRS has used it to seize the bank accounts of people suspected of structuring, that is, of making cash deposits worth less than $10,000 to avoid reporting requirements. This is a crime that most folks have never heard of, and as small business people will tell you, it's casts a pretty wide net, and it's catching a lot of innocent people. It's catching a Mexican restaurant owner, a gas station owner, dairy farmers. Many small business people then have had to fight expensive court battles to get even a portion of their money back, even though they didn't do anything wrong. These small businesses keep getting caught in the snares, largely because they're just that. They're small. Do a lot of transactions in cash, because believe it or not, we're still a very cash-driven economy, and in a typical year, American consumers do more than $1 trillion in cash transactions. And under the Bank Secrecy Act, it's illegal to structure or split up transactions in order to avoid a requirement to report those worth more than $10,000. To be clear, it makes it a crime to fail to file a report on certain transactions. Take an example. Say I'm a restaurant owner and I take $8,000 to the bank on Friday and $2,000 on Monday simply because I don't like to keep a lot of cash in my register. I'm not structuring. But if I do it because the bank teller says I can avoid filling out forms if deposits are smaller than $10,000, then I am guilty, even if I don't know if it's a crime. In either case, it may look like I'm trying to avoid the reporting requirement, and that's enough for the bank to file a suspicious activity report. At that point, the IRS can file a warrant and say it has probable cause to believe that assets are involved in a crime, and then it can seize the account. That's it. The IRS doesn't have to give notice to the account holder for seizing the assets, and the IRS doesn't have to prove that the person is actually guilty of anything, just that the account probably is involved in structuring. And after the IRS seizes the assets, the account holder isn't entitled to any sort of expedited hearing. So even if he did absolutely nothing wrong, it can literally take years of legal proceedings for the account holder to get some or all of his assets back. And many people simply can't afford a long, drawn-out fight. So what do? They settle, handing over thousands of fairly earned dollars to the IRS, all without having done anything wrong. We're going to hear from some of those victims today, and I know that there are many others out there who wanted to be here, like Carol Hinders, a restaurant owner in Iowa, Mark Zanowski, a gas station owner in Michigan, but they couldn't take time away because of family and business needs, but we've received their statements for the record. We also learned yesterday that the Treasury Inspector General for Tax Administration plans an audit of the IRS's practices in this area, so this inquiry will be forthcoming. And for the witnesses who traveled here to tell your stories, thank you for your time. We know that as small business owners, you're not drawing a salary here while you testify. We're also looking forward to hearing from Commissioner Koskinen, who I hope will be able to explain how this has been going on and what the IRS is doing to stop it. And with that, I'd like to yield to the ranking member for his opening statement.
Thank you very much, Mr. Chairman, for holding this hearing on the Internal Revenue Service. I am very pleased that we have the Commissioner with us today. I also thank the witnesses on this. The taxpayers were small businesses that made cash deposit from daily operation. We also were concerned that these taxpayers did not have a right to request a hearing in court within a reasonable period of time after the access was seized. I'm glad that the agency took action last October. The new IRS policy only allows the agents to seize access in certain cases. I look forward to hearing more about this change today. In closing, Mr. Chairman, I would like to state that I'm very concerned about the full effect of the agency's budget cuts on taxpayer service and enforcement. I think that we can all agree that American taxpayers deserve the best possible assistance. In the last year, the agency's funding was reduced by nearly $350 million. It is now at the lowest level of funding since fiscal year 2008. The growing gap between the agency's increased workload and the shrinking budget had led the National Taxpayer Advocate to state that the declining quality of taxpayer service is the most serious problem facing the agency. Mr. Chairman, I said in the past, and I've said again today, it is impossible to get blood from a turnip. We can do better, and we must do better. Thank you, and I yield back.
Thank you, Mr. Lewis. Commissioner Koskinen, thanks you for your time today and for joining us. The committee has received your written statement, and it'll be made part of the formal hearing record. You have 5 minutes to deliver your remarks, and you may begin whenever you're ready.
Now it's on. Thank you, Chairman Roskin, Ranking Member Lewis, and members of the subcommittee. Thank you for the opportunity to testify here today about an important subject.
Commissioner, could you pull the mic a little closer to you?
Sure. How's that? The IRS has sole jurisdiction to investigate criminal violations related to federal tax crimes. In addition, the IRS works together with various federal law enforcement agencies to combat other serious financial crimes, including money laundering, Bank Secrecy Act violations, and terrorist financing. In these efforts, we strive for a balanced approach that takes into account the need for fairness and respects for the rights of individuals under the law. The ongoing battle against financial crimes has been helped by passage of laws that provide law enforcement with tools to uncover hidden criminal activities. One of the most significant laws is the Bank Secrecy Act of 1970, which, as the chairman noted, requires financial institutions to report on individuals who engage in cash transactions exceeding $10,000. These and other similar reports constitute a robust set of data widely used by law enforcement agencies to uncover illegal activities both domestically and around the world. To circumvent these reporting requirements, individuals sometimes engage in structuring, where they intentionally manipulate cash transactions to fall below the 10,000 reporting threshold. Structuring may occur for any number of reasons. Individuals may want to conceal cash generated from illegal activities, such as drug dealing, or the cash may come from legal sources, but the person is trying to hide it to evade taxes. Whatever the reason, the law is clear. It's a crime to structure cash transactions for the purpose of evading the reporting requirement. Under the law, the IRS has the authority in structuring cases to investigate criminally and seize the assets involved in the structuring. But the law also includes procedures we must follow to safeguard the rights of individuals and ensure the seizure action is appropriate. Before an action can go forward, IRS agents must first prepare a seizure warrant affidavit that is reviewed by the appropriate U.S. Attorney's Office. The warrant then is presented to a federal judge who approves or denies it. If the judge authorizes the warrant, only then can the seizure and forfeiture proceedings take place. After reviewing our activities last year, the IRS announced in October that it would focus resources on cases that are more closely aligned with our strategic priorities. Specifically, the IRS will no longer pursue the seizure and forfeiture of funds associated solely with legal structuring cases or legal source structuring cases unless there are exceptional circumstances justifying the seizure and forfeiture, and the case has been approved beyond the approvals from the U.S. Attorney and a judge by a senior headquarters executive at the IRS. While the act of structuring, whether the funds are from a legal or illegal source, is against the law, IRS special agents henceforth will view the act as simply an indicator of whether more serious crimes may be occurring. This ensures that the IRS continues to focus its limited investigative resources on identifying and investigating tax violations within its jurisdictions that closely align with the IRS missions and key priorities. No one should conclude from this change that the IRS is backing away from enforcing the laws written by Congress by appropriately investigating both the source of funds and the purpose of the structuring when these cases arise. When the evidence indicates criminal wrongdoing has occurred, structuring will still be investigated and prosecuted where appropriate, often together with other crimes such as tax evasion and money laundering. We recognize that seizure and forfeiture are powerful law enforcement tools and must be administered in a fair and appropriate manner. The IRS understands and embraces the fact that we have a duty not only to uphold the law, but to protect the rights of individuals as well. We believe that our policy change will help ensure consistency in how IRS structuring investigations and related seizures are conducted and will also ensure fairness for taxpayers. In short, if a taxpayer is not violating the law and engaged in illegal sourcing, they have nothing to fear with regard to the seizure of their assets. This concludes my statement, and I would be happy to take your questions.
Thank you, Commissioner. I'll first recognize Mr. Marchant on the majority side, and I intend to ask my questions at the end.
Thank you, Mr. Chairman. Welcome, Commissioner. I was Monday in my district and held a meeting of about 50 people, and thought we were going to have a very nice lunch. As it turns out, I was the lunch.
I know that feeling.
And as much as I tried to talk about any other subject that we were working on in Congress, this group wanted to talk about the IRS. So as much as we may have thought the whole Lois Lerner event and the events of last year have passed, they have not in the minds of our constituents. Today we're here to talk about abuse, we feel like is an abuse of small business owners. Last year, a woman from Iowa, her name was Sue Martin-Ake, came to our committee and reported to us the IRS had targeted her pro-life group for extra scrutiny before it got its tax-exempt status. She even told us that her group was asked to tell the IRS about what they prayed about at their prayer meetings before the meeting. Now we hear about another Iowa woman who's been targeted by the IRS for doing nothing wrong. Unfortunately, Carol Hinders, she can't be with us today. She has an adult child that's sick and requires that she be with her, and she did not really have the money to travel down here from Iowa to tell her story, but she would like to tell it. This is Carol here on the screen. She owns a Mexican food restaurant. I guess with all the Texans coming up there for the presidential election, that Mexican food is a popular item in Iowa. Carol owned her small business, and she's owned it for 38 years. For 38 years, she's only accepted cash payments, and for 38 years, she has regularly gone to the bank and made deposits so that she did not keep large amounts of cash on hand. In August of 2013, with no warning, no letter, no prompting, her bank account for $33,000 was frozen, and the IRS informed her that she was structuring or was being suspected of structuring. It took her almost a year and a half to get her money back, and even so, she had to close her restaurant because she just could not afford to continue operating. Why would it take a year and a half for her to get her money back, Commissioner?
It shouldn't take a year and a half. There's a limited, unfortunately, I think too limited period of time for anyone whose assets have been seized to come directly to the U.S. Attorney and the IRS and administratively make a claim. But that time frame is less than 45 days. So what happens generally is people make their claim in the legal proceedings, at which point we lose control of it. It becomes a legal case, and in the courts it takes much longer than it would otherwise. And so it's, but there's no reason.
Once they seize that account, does the IRS agent have any burden of proof that they must provide to the person that the money has been seized, or his or her attorney or their accountant? Is there any burden of proof that they have to immediately provide to the taxpayer to justify the account being frozen?
As noted earlier, we have to, an IRS agent has to have the matter reviewed by the U.S. Attorney's Office, and the judge has to find that there's probable cause that there's been a criminal violation before the seizure even takes place. Once the asset is seized, if it goes into the judicial proceeding, which I say takes place very quickly, there's a limited time in which you can do that, and most people simply go to court. Once there, then the government, represented by the Justice Department, has to prove by a preponderance of the evidence that the seizure was appropriate, that it was, in fact, the result of a violation of the criminal law.
So when does the burden to determine whether the money was seized lawfully, or whether it was lawfully earned or not, when does that burden of proof have to be shown? Does it have to be shown to the judge before the money is seized, or is it proved in a court case afterwards?
We have to show probable cause to a judge before the seizure, and then in the court case, the government has to prove by preponderance of the evidence that in fact the seizure was appropriate.
Thank you, Mr. Thank you.
Mr. Lewis is recognized.
Thank you, Mr. Chairman. Mr. Commissioner, thank you for being here today, and thank you for your great and good work. Will you tell us, when did the new policy come into place?
Pardon?
When did the new
When?
policy?
New policy, we reviewed the matter during last year, and in October, we instituted the new policy that if there was not evidence of illegal sourcing for the funding, forfeiture would not be taken.
Well, why did the IRS change its policy?
We started looking at it earlier last year because it turned out there was no uniform policy across the country. Different U.S. attorneys' offices had different proceedings, and different judges responded differently. In some cases, if there was not illegal sourcing, there would not be a seizure would not be allowed. In other cases, if there was no evidence of illegal sourcing, the seizure could still go forward. And after reviewing it, we decided the better policy, to some extent making sure that taxpayers get appropriately protected, the better policy, if we're going to have a standard, would be that we would only have asset seizures when there was evidence of criminal sourcing, a source of criminality for the funds themselves. And so after the review took several months, in October we made that policy announcement.
Could you list for us some of the example of exceptional circumstances?
An exceptional circumstance would be without legal sourcing would be large volumes of transactions. The case of $8,000 on a Friday and $2,000 on a Monday would not be that. But if every day someone was magically showing up with $8,000 or $9,000 regularly during the course of a week, and that took place.
So if there's some pattern?
If there's some long-term pattern, and again, I would stress that that will not be a decision made by an agent in the field. That will only be a decision made by a senior executive at the IRS in our criminal investigation division. We do not expect that to happen often, but it would be where there is a unique circumstance where there's a regular pattern of violations, and it's clear that while we can't tell initially what the source of those fundings is, whether it's illegal or not, the fact that it's occurring every day over a period of time would be a significant change in an exceptional circumstance from the cases that we're talking about here today.
Mr. Commissioner, you heard me say that I'm deeply concerned about how the budget cuts have affected the IRS in this filing season. Will you tell us what impact the budget cuts are having?
Well, the impact is of great concern to us is on both sides of what I call the compliance coin. On the one hand, we now have 5,000 fewer revenue agents, officers, and criminal investigators, so our enforcement of many crimes, tax evasion, collection is down. But equally significant and important to overall compliance rates is that because we have 13,000 fewer people headed toward having 15 or 16,000 fewer, we simply don't have enough people to answer the phone. So our level of customer service in this, a very complicated filing season, is the worst it's been in years. And the people who care most about that are the IRS employees who want to provide information and support to taxpayers. But the level of our service in this filing season, which is going very well, I'm delighted to report, thanks to the good work of our employees, the level of service is still below 50%. That means your chances of getting through to a live assister are less than 50%. And that's just a miserable level of service, and one that we don't think taxpayers deserve. And there's nothing we can do. We have been as efficient as we can. We've moved as many people to the website as we can. We have apps if you want to know about your refund, if you want to get transcripts, if you want to actually make a payment, you can do that all online. We're trying to be as efficient as we can and move as many people there as we can. But the net result is we still have far more people calling than we're able to handle appropriately.
Well, thank you, Mr. Commissioner. And I yield back, Mr. Chairman.
Thank you, Mr. Lewis. Mr. Kelly is recognized.
Thank you, Mr. Chairman. Mr. Costin, good to see you. You know, in my life, running a small business and then trying to comply with everything that we have to do, one of the things that I've always worried about is, I know you made reference to you're working with less money. and it's making it harder for you to serve people. The fact that the tax code is so big requires having more people to try to help people navigate it. As a small business person, and we talked a little bit about Ms. Hinder, so $33,000 you seized from her, and maybe that's not that much to the IRS, but there's another person going to appear in the panel, $900,000. In my business, having access to capital is critical. So when somebody can seize those assets based on their interpretation or their belief that somehow you have been helping somebody launder money. I've always related having cash in my store is to having blood in my body. Without that cash, you are dead. Now, so when the IRS does it, whether it's a seizure or an audit, but when you can seize somebody's assets based on somebody's English, you know what, I think these people are involved in something. You can kill them as a person, as an entity, as a business. Is that not true?
That's true, but we don't do it just thinking about it.
No. Listen, it's solely up. You are the judge and the jury when you decide to go after these folks.
That's not true.
It is true.
No, it isn't. I've told
Commissioner,
you.
you and I have met before.
Pardon?
Now, listen, you and I have met before. You told
Yes.
me at one time the definition that you look at when it comes to taxpayers, those that want to pay tax and those who do not want to pay tax. I would tell you that in the private sector, there is nothing more chilling than any kind of communication from the IRS. First of all, we don't have access to capital. Once you seize those accounts, how would I go to my lender and say, you know what? They seized my bank accounts. I still want to keep my business open. I haven't been found guilty of anything, but it's under suspicion. Now, I understand you walked us through how that works, but the reality of it is, for Carol Hinders, who's she going to get to fight that battle for her? How is she going to stay open when you've seized her accounts? And these are the exact people that we're looking for to keep the country going forward. These are the people that supply all the coal for the furnace that heats the whole country. I don't understand this. I really don't. How can you be guilty on a suspicion? This just flies in the face of everything we are as a country. Have you ever been in that position where somebody can come in and seize your assets? This is yes or no. It's probably, if it hasn't happened to you, it hasn't happened to you.
I'm sure we're all in that position.
No. But have you actually been in it where somebody seized your assets because they think you may have been guilty of some wrongdoing?
No.
Okay. Would you think it was an overreach if somebody had that ability to do that too?
If they could do it on their own and without any evidence that I'd done anything wrong, I think it would be an
No.
overreach.
That's not it. They haven't been found guilty of anything yet. This is on a suspicion that they may have done something wrong.
As I say, I think it's important for the record to know we don't make that decision by ourselves. It takes the U.S. attorney and a federal judge to agree that there is probable cause.
But it's not the due process of law that we have as individuals in this country. Citizens are protected from an overreach by a government that can find them guilty without ever having it. The suspicion of it is one thing. The ability to shut down a business or a person, limit their access to capital, and put them in a position. If you've ever had to sit across from a lender and try to explain who you are and where you are and why you need them, they say, all your assets have been seized. Is that correct? And you say, yeah, they have, but no buts. We can't help you.
Right, and I think it's an important issue. The reason
It's not important. I got to tell you, it's far beyond important. Important is dismissive. It is freaking critical. We are killing these people on a suspicion that they may have done something wrong. This flies in the face of everything this country was built on from day one. And if you can sit there and tell me that somehow you went through a process that allowed you to seize assets of people who are getting up every morning, throwing their feet out over the bed, going to work to put a roof over the heads of their children, food on their table, clothes on their back, and get ready for the future, and say, but that's okay because, see, we went through a process that allowed us to seize those assets. So we're going to find out if they're guilty or not. And how long does that process take? How long would it take before I would find out if I'm still allowed to be in business because the IRS says, you may be guilty of something, I'm going to shut you down? What's the average time?
I don't know what the average time is. But
Okay, I'll tell you what, you would, if you were in business and somebody did that to you, I got to tell you, access to capital, access to cash is the same as having access to keep your body running and when you run out of blood. It is incredible that this organization can do that on a suspicion of wrongdoing, shut somebody down, seize their assets, and put them in a position where they can't possibly survive. You talk about waterboarding. This is waterboarding at its worst. I thank you, and I yield back.
Mr. Rangel is recognized.
May the record indicate that I have the same amount of emotion on that Mr. Kelly does. If certainly something like this has happened, let's see whether I can defend our country and our agency in any way possible. First of all, under this new policy change, nothing like this could probably happen again?
Our hope is, and our plan is, and our expectation thus far is that nothing will happen like this. We it will not be
Second, under the existing law, it's nothing in the existing law that says there has to be criminal intent. The law.
No, actually, the law passed by the Congress says that you don't have to have a criminal intent to violate the law. You simply have to be not providing information as required by the law. So if you are
And so the
consciously
judges and the assistant U.S. attorney said that if taxpayers, if there's no evidence of illegal sources or anything, still they would go through the process merely because the law said it was before you changed the policy?
The policy was that it is a violation of the law to structure your assets. So if you're in your deposit, and if you've structured your deposits under the law, it's a violation.
And
we're not
structured means that a consistency that is below $10,000.
Correct.
And from that, you infer that you can seize someone's property without showing any evidence that they intended to violate the law. That was the policy?
That was a policy. That is the law, actually. You have to have an intent to avoid the reporting requirements. You don't necessarily have to have an intent.
So
to
you're
violate.
trying to say that it's the Congress that enacted this law that just doesn't make any sense at all that you should do this to anybody, anybody that has no criminal intent and for whatever reason wants to structure their deposits in a bank and there's no evidence of wrongdoing. That law, to me, is unconstitutional, unreasonable, and stupid. So the only way that you can do this is by having tax reform, I would think. Do you have any other ways to change this besides changing the policy?
Well, as I say, we've changed the policy from our standpoint. Historically, only in a third of the cases of investigations were there ever seizures to begin with, and the average of those seizures is well over $100,000. But the policy would say, and does say, and has been in effect since last fall, that if there's no evidence of criminal sourcing...
Look, that is good, and it makes me feel good. I hope it makes Mr. Kelly feel a little better. This never should have happened in the first place, is what I'm saying. And I hope you would agree that whether or not it was within the law or not, it is wrong without any criminal evidence to seize somebody's property merely because it falls within the four corners of the law. Because the law doesn't make any sense. There's nothing wrong in doing this. I'm a former assistant U.S. attorney. Every case I've seen is people buying luxury cars, expensive jewelry, and the vendor putting in deposits of over $9,900. A bunch of crooks.
Yes.
Now we find a bunch of innocent people doing the same thing for non-illegal purposes, and you're enforcing bad law.
And we are actually making it clear that if you
Well,
haven't
you're
done
making
anything
it clear
illegal,
now, Commissioner, but common sense and decency would say when the Congress screws up, we expect you people to come back to us and say, this is not working. You've done this in policy, and there has to be some way that we can tell the people that have been victims of poor judgment that we regret that this happened. So let's move on and agree that we should reform the tax system. Thank you. I yield back the balance of my time.
Thank you, Mr. Rangel. Mr. Meehan is recognized.
Thank you, Chairman. Thank you, Director, for being here today. You identified that you spoke to the New York Times and changed this policy publicly. What were the reasons for the changing of the policy?
Changing the policy, as I noted earlier last year, as we began to look into the situation, it was clear that there was no single policy, and that if we were presenting evidence in some jurisdictions to U.S. attorneys in courts, there would be a seizure, and other jurisdictions there wouldn't. So we looked at the entire question of how this law is applied and came up with the decision that the right balance between law enforcement and trying to protect taxpayers was when there was no evidence that the funds were from illegal sources, there would be no seizure.
So that's the inconsistency you're trying to say.
So we decided if we needed to have a standard policy for the IRS and when we would request seizures, and the policy would be we would not request a seizure if there was no evidence of criminal sourcing.
Do you think there were abuses of this policy in the cases that you oversaw?
I'm not familiar with individual cases, but I take Mr. Kelly's and everybody's concern that if a business has legitimate reasons for depositing cash regularly in amounts that avoid otherwise the Bank Secrecy Act, if they've got legitimate reasons for that, then they should not be subject to seizures, and that's our policy.
Because, I mean, I can see the value in a program like this as a former prosecutor, but you can also see the ease with which this can be manipulated to get ends that are, because it's an easier way to go. I mean, probable cause, you've mentioned this a couple of times. What's the underlying probable cause?
The underlying probable cause at this point would be evidence that, we have evidence that there's criminal sourcing involved.
That is, so now it's going to be criminal sourcing. When we did these before, the probable cause, you said you...
Probable cause before would have been that
Just
that there
simply
was
the act of structuring.
structuring.
Okay,
Exactly.
alone. So this does not tie back. Now we're going to make sure that it's a two-step process, that it includes at the initial determination that there has to be some kind of evidence presented to the judge and by the U.S. Attorney before there will be a seizure that will be initiated.
That's correct.
Okay. I tried to figure out where these you were in 2012. Of course, to the statistics that I have seen, there's been 5 times as many structuring related seizures as there was in 2005. 5 times as many. Half of the total were for less than $34,000. Does that look to you like the kind of big drug-related or terrorist-related incident that we're trying to prevent?
Well, the average of the seizures in the evidence data I have goes as high on average as well over $100,000.
That's the average, because you have some big
Smaller,
seizures, and I get you, but half the people
Half the people.
who
Well,
have been are less than $34,000.
And under this policy, if that 34,000 had no indication it was coming from criminal violations, there would be no seizure. I would note, for the record, 60% of the cases, when there is a seizure, nobody shows up, which means that in 60% of the cases, there are criminals who don't even want to see the light of day and are happy to give up the money. And part of the reason for the seizure is to try to, in effect, undercut the ability of organized crime, drug dealers, and
But
terrorists.
80% of these cases were civil cases. They weren't criminal. 80% were civil.
Yes, because you have a criminal case, you have to have a criminal defendant. And as you know, in drug cases and terrorist financing cases and other times, oftentimes we can't get the individual, so we're stuck with the civil procedure and forfeiture, which is against the asset. And if we're going to...
What do you mean we can't get the guys, so we're stuck with a civil? I mean, this is
we
due
actually
process.
will
This
seize
is
the
America.
asset. We'll seize the asset in many cases, and the owner of that asset will disappear. Will not show up. 60% of the cases, the owner of the asset does not show up. That means in 6% of the cases, one could surmise that they had a good reason for not showing up, that they in fact did not want to subject themselves to further legal enforcement.
We're going to hear from Mr. Clyde later. I went through some of his testimony, and in the course of it, he did show up. Now, he showed up numerous times because they were being leveraged. A $900,000 seizure of his business was negotiated down numerous times, in which by the final time, the IRS came to him and said, you will settle for $109,000.
The IRS did not do that. The negotiations on settlement, once it goes to court, are within the realm of the Justice Department and the U.S. Attorney. The
So
only
this
time
is-
we settle is if in that window of administrative proceedings before you have to go to court, if you come to see us, you will settle with us, and that's a handful of cases.
So you're putting this on the U.S. Attorney. That may be, but here's my problem with this, because again, we're using the system. And this is going to be his testimony. I read the testimony. He said they came back and they offered to settle for only $109,000. And they reminded me, this case could easily go criminal against me personally during discovery. Now, you know it's unethical to leverage a civil case by threatening a criminal prosecution.
That's correct, and I
That
don't
is
think
correct.
that's an IRS agent that did that.
Is Mr. Clyde lying when he's testifying that this happened to him?
Does he specify that it was an IRS agent that told him that?
He specifies that he was leveraged, that if he did not settle for $109,000, this could be a criminal case.
Exactly what you say. We would not threaten him, and I don't think that's an IRS agent.
Thank you, Mr. Koskinen. I appreciate it.
Mr. Crowley is recognized.
I think the big distinction there, Mr. Commissioner, would be whether it was the prosecutor or the IRS agent, or agent of the IRS who was making that innuendo, which is, I think, is a very valid point. And I think, Commissioner, welcome, but I think you recognize by the angst on both sides of the aisle that this is a bipartisan issue of concern, of overreach by the IRS. And while we haven't officially heard from the witnesses on panel 2, I've read their testimony. It's horrifying to me as an American. I think most Americans, if not all Americans, who read those stories about the IRS, as well as the U.S. Attorney and federal judges who have the ability to seize Americans' bank assets for no legitimate reason, all the while never charging them with a crime. That policy robbed hardworking people of their cash without any proof of crime. And whether you're Democrat or Republican, green, purple, red, or blue, it's wrong. The people before us on panel 2 are victims. They are not criminals. We all recognize that the IRS is a powerful agency. And at times that power is justified to crack down on what Mr. Mean was speaking about in terms of terror financing or drug laundering or tax evasion in itself. But that power must be measured and used appropriately to get to criminals and not trap innocent American citizens. That's why I hope that these civil asset forfeitures against people who committed no crime appears to be something of the past. Could you explain the changes you undertook as commissioner on civil asset forfeiture?
As I noted, the changes since I've been there are we looked at reports that had come in about varying policies across the country, reviewed the entire policy, and decided that the appropriate policy was if we didn't have evidence of criminal sourcing for the funding, there would not be a seizure. And there had been cases, some jurisdictions where that was already the policy, other jurisdictions it was not the policy, and there were seizures. And I'm sure some of the people you'll hear from were in those jurisdictions. And we decided the right policy was to have a uniform policy and not have seizures unless there's evidence that you, in fact, were involved in criminal activities. We'll continue to investigate, as we will evidence, but we will actually proceed. And in some cases, it has turned out to be a very good development of the policy because instead of simply relying on a seizure to begin with, we've actually uncovered with further investigation more criminal activity. So the policy decision was to have a uniform policy and to make this decision that it would be uniform, that if you weren't engaged and there was no evidence you were engaged in criminal activities and the source of funds was from criminal activities, you would not be at risk of a forfeiture.
I do hope that that policy, as you said, is effective, and if not, I think the Congress will continue. Well, we will continue to have oversight regardless. I would like to get your thoughts on the bipartisan legislation written by Sandy Levin, the ranking member of the committee, to allow affected taxpayers the right to a probable cause hearing within 14 days or have the IRS return the seized funds. What are your thoughts on that?
As I say, I think the ability to come in an administrative way without having to hire a lawyer and go to court, that time frame under the law is in the range of 30 days, and I think that's too short. I think that we ought to give people the chance to come in before they have to hire a lawyer and go to court to make their case. As I say, well, hopefully we won't have these cases going forward. The only problem with, and so I have no problem as a general matter with making
We're a matter
sure
of time.
people, my concern is whether 14 days is going to be
Long
very
enough
short,
to do
even
that.
for the taxpayer and us. But if it were some reasonably short period of time, I think that
That's
taxpayers ought to have a chance to show up. As I say, 60% of them historically, even under the old policy, didn't show up, but that was an indicator of what they were about. But I agree totally that these are important matters. It's important to make sure that innocent taxpayers are not dragged into a system inadvertently, and that if they, even with our policy, if they think they've been wrongly included, they should have a prompt way to be able to raise that issue.
I appreciate it, Mr. Chairman. I have limited time. Like many of my constituents, I read with disgust and shock the stories reporting the IRS rehired a number of former employees who had troubling work records during their previous stint at the IRS. Please tell me that these stories are incorrect, that they have not been rehired.
Historically, in 2009 to 2012 area, there were a handful of people with prior employment problems, primarily seasonal employers. We hire 8,000 to 10,000 seasonals a year who had prior issues. We have agreed with the IG's report on this, and I've had meetings in the last few weeks to make sure that we look at very carefully, particularly those who have been willful violators of the tax code, to ensure that we consider that before any hiring decision is made. And so the handful of cases the IG found, I think, will not occur, and those were a handful out of the 73,000 hired over those several years.
Mr. Chairman, let me just say for the record that I appreciate the response by the Commissioner, but I do think that more investigation is warranted, and I associate myself with your letter dated February 6th asking about current hiring practices at the IRS. And with that, I yield back the balance of my time.
And we're responding, and we'll respond promptly to
Thank
that
you,
letter.
Mr. Commissioner.
Thank you, Mr. Chairman. A few specific questions about the new policy. One, the new policy that's dated, October of
October
14?
Yeah, 2014.
17th, October
But,
17th.
the date is actually October 17th, yes.
Okay. Is it retroactive to cases that were in the works pending beforehand?
No, it is not retroactive in the sense that if there are cases before that, they're in the judicial process and they will be resolved however the judicial process would resolve them.
Right, so there could be plenty of legally sourced structuring cases, prior to the date of your new policy. Do you think it's fair that people who are prior to your policy are being treated differently to folks subsequent to your policy?
Well, I think that, as I say, our hope is going forward, no one runs into this problem.
But is it fair to the people who happen to have been caught in the web before you changed the policy?
Well, as I say, at this point, they are, as noted, and it, unfortunately, if it takes that long, but they are in a process that allows them, through the courts, to raise their challenges and their defenses.
The U.S. Attorney could step in and withdraw the case.
They could do that, but
Plenty of precedent for that.
Yes.
Crack resentencing guidelines. They've decided, on a department basis to apply these things retroactively. Would you advocate applying your policy retroactively?
I always try to be careful not to tell another agency what their policy ought to be, but it is, I think, appropriate for the U.S. for the Justice Department to consider.
You're telling them what their policy ought to be with your new policy.
I was going to make that point earlier. I should stress there are a wide range of federal agencies, the Drug Enforcement Agency, the Justice Department, the FBI, and others who have seizure authority. Our policy, all we can do is make a policy for the Internal Revenue Service. My understanding is the Justice Department is looking at our policy in terms of applying it itself in other cases. But I can't tell you that our policy will be the policy other agencies follow. It's just the policy we think is right that draws the right balance.
To follow up on one of your answers to Mr. Meehan, are you saying that under the new policy that you have to aver that we have probable cause to believe that an illegal act is taking place other than the act of structuring?
Yes.
Okay. You sure about that?
That's what I'm advised by the people who run the Criminal Investigation Division.
I've taken a look. The staff pulled for me, a case from North Carolina, from my former prosecutorial district, after your policy change, and I've read through the affidavit and the associated documents. There's no allegation of illegal activity other than the act of structuring, and I believe if you looked at cases, there's been no change in practice of alleging some illegal act.
If that case exists, then it's not following the policy. I've been advised. I've had lengthy meetings with the senior leadership of our Criminal Investigation Division, which handles this, and have been assured that that is the policy, that people have been trained and advised about it. So if somebody's not following the policy...
Do you know how your policy has been communicated to the U.S. Attorney's offices?
Our policy would... the U.S. Attorney isn't the one that's making this decision for us. We present
the U.S. Attorney
case.
is the one who takes it to court for you.
It's
So
right.
that is your gatekeeper to getting due process.
Right, and so what we've done is had the policy. It's been a public policy. We've announced it. It's been in the press. We would not go to the U.S. Attorney under this policy unless we had the case that fit the criteria.
So do you think that your new policy creates a situation where if I'm a claimant, that I'm reading through the affidavit against the thing, the sum of money,
Yes.
and it does not aver a criminal act on my part, that I have that I can go to the judge and say, this is an insufficient affidavit here. It doesn't allege any criminal activity other than the act of structuring.
My understanding is that the private citizen should have the ability to do that. Our policy is that we would not
So
be...
you've created defense. Your policy creates a defense, is what
Surely.
you're saying.
Yes.
Okay. how do you anticipate that?
I guess I should answer to be careful. If you are structuring to avoid the reporting requirement, it's still a crime.
I understand that, but what
we
you're
w-
saying under
as
your
we're-
new
under
policy,
our policy, we're
I
not
have a
going to seize
I have a defense
to the seizure
to that seizure by
that
saying
we have
that
not provided
you haven't
any evidence.
alleged, you haven't presented any
alleged.
probable cause that there's an underlying criminal act on my part other than structuring.
Structuring, that's
for your
correct. That's
testimony.
our policy.
All right, Mr. Chairman, I yield back.
Mr. Smith is recognized.
Thank you, Mr. Chairman. Commissioner, I would like to start out reading the IRS mission statement. It says that the IRS's mission is to provide America's taxpayers top quality service by helping them understand and meet their tax responsibilities and enforce the law with integrity and fairness to all. Your mission is not to enforce all laws, it's to enforce tax laws, correct?
Correct, although we do cooperate on task forces with drug dealing and others at the request of other agencies.
You don't enforce drug laws, you cooperate.
We cooperate.
You
That's
enforce tax laws,
correct. We enforce tax laws.
not banking laws?
Banking laws to the extent that bank security, that there are laws that provide us or require us to, in fact, be aware of violations of the law. But basically, our primary function, as I said, with the
So what
only
does that
agency
mean?
that enforces tax laws.
So you don't enforce banking laws? You
No,
just
we're-
look at banking laws?
Yes, we are aware of the banking laws. We are on task forces because we are a law enforcement agency. We have law enforcement powers, and we participate in joint task forces at the request of other agencies because
Okay.
our agents are very good at tracking money. We probably are the best people to deal with complicated financial structures of anybody in the government. So
All right.
U.S. attorneys are forever asking us to be involved in cases.
I get it. I've looked at the Treasury Forfeiture Fund accountability report for 2013, and it appears that the IRS cases that the report touts are some that are related to your mission, such as tax evasion and unlawful tax shelter cases. But structuring payments is not a tax crime, correct? It's a banking law.
The banking law, the Bank Secrecy Act, correct.
Okay. So how often do you find tax evasion cases from structuring cases?
I can't give you a number, but any number of people are in business structuring their deposits so we don't get reports of how much cash they have. The highest level of underreporting in the tax gap, which I'll testify about this afternoon, is small and medium-sized businesses where we have no other third-party reporting historically.
So you have no number.
I have no numbers about what percentage of the cases we're dealing with are tax evasion, other than that's the primary purpose of our activities.
So the primary purpose of your activities is looking at structuring to find tax evasion, but you have no idea of what amount of number those cases are. Is that what you're saying?
Which ones turn out to be tax evasion cases as opposed to drug cases or terrorism cases? No, because we actually are involved in those cases as well. But I can find out if we can get you that data, and we'd be happy.
I think that would be data the committee would like.
We'd be delighted to get you the data about how the cases break down.
Okay. So is the IRS devoting any time to enforcing banking laws at all?
Yes, as I say, we participate at the request particularly of U.S. attorneys in the tax division of the Justice Department and others in a range of cases. We're involved in money laundering cases. We've been involved in drug cases. We've been involved in terrorist financing cases at the request of various agencies because we have a very skillful and qualified set of criminal investigators.
So you've been involved in some drug cases.
Yes.
What's your involvement in any structuring cases in the state of Colorado?
I don't have that data.
I would be very interested, and I think the committee would be interested to see if the federal law is being enforced under the structuring in the IRS code.
They'd be happy to. Again, the data would show last year we had 146, last fiscal year 146 seizures. So it's not as if we have thousands of these cases. But I'd be delighted to get you the data to the extent we have it on Colorado.
Out of those 146 cases, were any in the state of Colorado?
That I don't know, but I'll get you the information.
I would like to have that. Thank you, Mr. Chairman.
Representative Noem.
Commissioner, it's important to set goals for an agency. I believe that it's important. Do you believe that that's important to have goals as well?
Yes.
I've been reading through your forfeiture fund annual report, and it's interesting to me that the IRS has set its goals based on the number of seizures, based on the size of seizures, and based on the amount of money in seizures.
That's not a goal of the IRS. In fact, the law prohibits us, the restriction on to have goals tied to actually collections. So none of our employees are measured by the dollars they collect.
Well, that's the concern that I have, because based at my evaluation of the report and the fund, is that that is what the goals of the IRS are, and that concerns me if you're going to be
That's a
basing
report
it.
from the Treasury Department. That's not an IRS fund. We do not control that
But the
fund.
data would be the same. I mean, the
Data-
data indicates,
We have volumes of data, some of which I'm going to provide to this committee, about the number of cases, the amount of seizures, but those are not goals that are measured for performance of our agents. Those are
So,
the results of our activities.
could you clarify for me then, does the IRS have any goals that would indicate it's going after lawfully earned money?
We have no goals at all that would it would tie anybody's performance, including the agency's performance, to collections under any of those activities.
Are your agents motivated at all by goals set by the agency to put points on the board?
None at all. It's illegal for us to have goals that cause any agent and any IRS employee anywhere in the organization to have a goal tied to collections.
Is part of their evaluation for doing their job based on any kind of dollars of seizures that they have produced, by seizures that they have been a part of, or the size of those seizures? Is that a part of their evaluation as their work as an agent?
That's a very important question. I'm delighted you asked it. It is never a part of their evaluation. We are across the board prohibited from, whether it's a revenue agent, a collection agent, somebody in sending you a notice, we're prohibited from having anybody rewarded on the basis of the dollars they collect.
So
And I think
even if
that's
an
important
agent
for
is,
taxpayers to understand.
even if an agent is in a situation where they've seized an amount of dollars, but yet they settled for less, that's not going to be a part of their evaluation as to doing their job duties.
A, that settlement is not an IRS settlement. B, even if it were, it would not be part of their evaluation.
Okay.
We
You-
settle cases. We have revenue agents negotiating with taxpayers across the country. What their settlements are is never toted up in terms of performance and never measured in terms of performance
Your criminal investigation division has field offices, correct?
across the country.
Are they evaluated based on what kind of seizures they've participated in and investigated in?
Absolutely not.
How are they evaluated?
They're evaluated on a set of normal performance measures in terms of their activities.
So if they're not performing well and they're not getting very many seizures or aren't producing very many seizures, does that reflective on the work that they are doing, and are they then motivated to go after easy cases or easy seizures?
Now, you have to understand the seizure investigations are about 5% of the work of the Criminal Investigation Division, and about a third of those result in seizures. So in 2/3 of our investigations, there's no seizure, and the investigations totally are about 5% of their activities. So we are involved with identity theft, chasing criminals. We've thrown 2,000 people in jail for, thanks to cooperation with the Justice Department, who prosecutes those cases for identity theft. So the vast majority of their time is not spent on seizures or on those investigations.
See, here's what concerns me about your new policy, is because it says that there could be exceptional circumstances that would change the policy if that was necessary. So if they are short on goals, if there's not many seizures happening, it could easily be declared that there are exceptional circumstances that could be utilized to raise those number of seizures and the amount of dollars that would be captured.
The number of seizures is not a performance goal, so they have no incentive to do that. The second point to remember is no agent and no field office has the ability to make that determination. It is made by a senior executive at headquarters in the Criminal Investigation Division to make sure that they really are exceptional circumstances to change the policy.
And is that written policy that every agent and every member of the Criminal Investigation Division team would know and be very clear of?
Every agent has been advised about that, is being put into our revenue manual that everybody follows, but once that policy was initiated last fall, it was distributed and shared throughout the agency. Every agent should be aware of that policy.
So to your knowledge, there's been no evaluation processes that have been gone through where seizures were discussed or talked about, or even the settlements that resulted from those seizures?
Settlements and there are, as I say, it's illegal, and I think it's appropriately illegal for us to measure anybody's performance by their collection activity.
Thank you, Mr. Commissioner. I yield back.
Mr. Johnson is recognized.
Thank you, Mr. Chairman. Thank you for letting me join you today. Mr. Commissioner, welcome. I'm here to try to give voice to my angry constituents who are angry over the president's unconstitutional executive amnesty. And here's the truth of the matter. Obama's executive amnesty isn't just about immigration, it's about taxes also. And that's what I want to ask you about today. This is what the president had to say back in November when he announced his executive amnesty. Quote, "Now, here's the thing. We expect people who live in this country to play by the rules." The president later on said that among the requirements for getting his amnesty is, quote, "You're willing to pay your fair share of taxes." Mr. Commissioner, I've got some questions regarding the Earned Income Tax Credit, a refundable tax credit that can result in thousands of dollars in cash back from the IRS. First question, isn't it true that in order to claim the EITC, the tax filer, along with the dependents, must provide a Social Security number, yes or no?
That's correct.
So in other words, no number, no EITC.
That's also correct.
And just to confirm, if you're here illegally in the United States, you can't get a Social Security number. Is that true or false?
That's also true, but you can file taxes, which hundreds of thousands of illegal immigrants do.
Isn't it another requirement of the EITC that income must be earned, yes or no?
Yes.
So in other words, one needs to work in order to be eligible for EITC. So I think we've made it clear that the EITC only for those who can legally work for the United States. But isn't it true that Obama's executive amnesty will allow some who have been here illegally to get Social Security numbers, yes or no?
They can do that, but the law, the EITC and our law generally about working is we encourage, the law encourages and our process encourages illegal immigrants to pay taxes. And as I say, we have almost 700,000 ITINs, as they're called, out there, and people illegally in the country have been paying taxes for some time.
But with a Social Security number, they can claim the EITC.
That's correct.
Okay, now I heard you say last week that an illegal who gets a Social Security number, thanks to Obama's executive amnesty, can actually claim EITC for years in which he was illegal by filing amended returns. Is that correct?
That's correct. They would have to have been working in those years. As you noted, you can only get the EITC if you're working. The law doesn't say legally working. The law simply says it's tied to people working. So if you have not worked in the past, you won't be eligible for EITC whether you got a Social Security number or not.
Well, say such an individual gets a Social Security number in February of this year. What is the maximum earned income tax credit that this individual can get if he files his return, including amended returns as per the statute of limitations by April 15th?
If you're a single person, the maximum you can get is in the range of about $600. If the maximum you can get if you're a family with 3 children or more is close to $6,000. So if you're an individual worker, you would get $600 this year. And if you had worked for the previous 3 years, you could file an amended return and get another $1,800.
Well, joint tax tells us that individual could get a total of $23,800 for the year 2012 through 2014.
You'd have to be married, have more than 3 children, and if you were filing an amended return and had worked for those 3 years, you would be able to get that amount.
Well, the truth is, I say, thanks to Obama's amnesty, illegals will be getting thousands of dollars from the IRS, and I feel like that's kind of outrageous, and it's wrong. It's not fair. It's not right. So let me make it clear. I represent hardworking, law-abiding Texas taxpayers, and elsewhere in my district, I took an oath to support and defend the Constitution, and I think these amnesty rewards, and that's what they are, need to be stopped. Thank you, Mr. Chairman.
Thank you.
Commissioner, you mentioned to Mr. Holding that the new policy involved a defense. Did you mean a legal defense when you said that?
Well, what I meant was, I'm not a practicing lawyer, I haven't been for some time, is that our policy is that if there's not evidence of illegal sourcing, we cannot establish, will not try to establish probable cause. So I
understand that. So, but just to be clear, that gives the IRS all the ability to make the initiative. In other words, a defendant is not able, based on that policy statement able to come in and assert, hey, the New York Times reported that the IRS isn't going to do this anymore. Do you follow me? So it's not an actual defense. It's a
I'm sorry,
discretion.
that's a good point. And as I tried to make clear as well, if the structuring has taken place, it's a violation of the law. We're simply saying that we're not going to go after asset seizure if there's no indication of illegal activity. But the law still says that if you are consciously trying to avoid having a bank file a $10,000 above $10,000 what's called a currency transaction report, if you're trying to avoid that, that's a violation of the law that the Congress has passed. We're simply saying there's no illegal activities. We're not seizing your assets in that case.
So will you be amending the Internal Revenue Manual to reflect that?
Yes, we've already instructed the agents, but we are going to change the Internal Revenue Manual to try to make sure across the country that that's a uniform policy and uniformly applied.
What's the timing on that, on the change to the Internal
So
Revenue Manual?
someplace an expectation it's going to take years. I mean, it takes us, in fact, if it's not in the IRM, it'll be there very quickly. It's, changing the manual, it does not take forever.
Okay. So you would expect that done in 2015, for example?
Certainly before the end of this quarter, if it isn't already done.
Excellent. One of the things that that I think Mr. Weber said at the time was for the change was an argument about an allocation of resources. So if theoretically, if the IRS were to get all the resources that it was requesting, would that, I mean, that suggests that they could maybe go back to the legal source structuring. Or can you assure us that that is not going to happen? I can assure you that we have no intention of going back to seizing assets where there's legal source structuring. Okay. I want to contrast, to follow up on Mr. Kelly's line of inquiry a little bit, and that is to really highlight this power relationship and how it's unique in the seizure situation, and contrast it with an audit, for example. You know, if a taxpayer gets notice from the IRS that there's an audit, it's a different process. Can you walk through the taxpayer protections that someone has for an audit that they don't have in a seizure, for example? Well, let's say in the seizure, we should not forget, while it takes too long sometimes, there is a court process that is available to a taxpayer immediately. So they have the protections of the legal protection of the legal service and the court process. The fact that in some cases it may take too long, I think, is an appropriate concern, but it's not as if they're out there without the ability to immediately go to court and make their case. But in the audit, to get to your point, we'll send you a notice if we find there's a problem. I would stress that we do that on the basis of computerized analysis and matchings. We'll send you a notice and say, hey, we think there's an issue here. You then can write us back and say, yep, I agree, and here, and it's over. Or you'll say, nope, that's fine, and we will then have 2 or 3 correspondences by letter. As I've said, if you hear from us for the first time by phone, you're not hearing from us. The phone scams going on of people making threats over the phone from the IRS are just that, scams. But to that point, I mean, the audit is for a discrete period of time, isn't it? It's usually for a given year, and it's about a specific issue. We will then, if we can't by correspondence do that, we will then have a revenue agent or officer will show up and set a meeting with you. My point is there's a lot more certainty. There is certainty as it relates to what's the subject of this inquiry, what's the duration of the inquiry. I can prepare for this, and you still have the taxpayer in this case would still have access to all their resources and everything until it's ultimately disposed of. Exactly. And if they disagree with us when we come to a final assessment, they can go through our appeals process, and then they can go to court. So you can understand then how someone feels fundamentally different about an IRS inquiry that looks and feels different. The seizure is fundamentally different. All the power is with the IRS. All the power to come in and say there is something going on. And I think part of what I want to draw your attention to, and it was in your own testimony, in your written testimony, you said the purpose of these sorts of efforts is to disrupt and dismantle criminal enterprises. I mean, just correct. Without any question, there's nobody on this panel that's going to quarrel with the use of government power to disrupt criminal enterprises, and yet the witnesses that are going to come after you today are not criminals. They didn't do anything remotely related to the type of enterprise that you're being that you were citing in your testimony. I'm going to read to you from testimony, congressional testimony from the Department of Justice head of asset forfeiture, the asset forfeiture fund. He said this about the forfeiture law. Forfeiture undeniably provides both a deterrent against crime and a measure of punishment for the criminal. Many criminals fear the loss of their vacation homes, fancy cars, businesses, and bloated bank accounts far more than the prospect of a jail sentence. But take, Mrs. Hinder's story. There's nothing remotely related to that type of criminal activity in Mrs. Hinder's story, or in the witnesses that we're going to hear from today, Mr. Clyde or Mr. Hirsch or Mr. Sowers. So you have an opportunity here before these people. Would you, on behalf of the IRS, be willing to apologize to them for the way in which they've been treated and working forward, even re-engaging with Mr. Holding's inquiry about doing your best to influence the U.S. attorneys in these cases? But would you be willing to apologize to these people on behalf of the IRS?
Well, I'm not allowed to know any of the details of individual cases, which is appropriate, so I can't talk about individual cases.
But you've had notice about who our witnesses are, so I'm not asking you to disclose anything.
No.
But know their stories are public and they've been aggrieved. There's no question, right?
There's no doubt about that, and I regret. We take, as the mission statement says, very seriously our responsibilities to taxpayers. The IRS does have a lot of enforcement powers. Even when you get a letter from us, it's not a fun day in your life. And we try to take and balance that as much as we can. We pulled together early last year a taxpayer bill of rights to try to let taxpayers know.
But I mean, just so we're clear.
So my sense is, going forward under this policy, we should not have people in the circumstances of the witness following us, and that's the goal for the policy. To the extent that people have gotten wrapped up in the system and it's taken too long to resolve it, I regret that. That's a problem with the system. The question was asked, shouldn't there be a way for people able, however they got there, to come in quickly? 14 days may be a little short, but there ought to be a way efficiently for people to be able to come in and make their claims. As I say, 60% of the people just disappear, who are the criminal types we're chasing. But even with the policy, I do think that we ought to make sure that there's a way for people efficiently and quickly to be able to say, well, okay, there's an allegation of criminal issues, or in fact, if some agent doesn't follow the policy, to be able to come in a reasonable period of time and be able to make their case without hiring lawyers, without waiting for a year or two. A year or two,
Commissioner,
and the rest of these are out of the question.
The IRS grabbed these taxpayers by their throat and squeezed them and squeezed them and squeezed them without mercy and nearly ruined them and made their lives miserable. Would you be willing today, on behalf of the IRS, to apologize to those taxpayers who were so abused?
Anyone who actually was not engaged in structuring, was not engaged in processing and laundering illegally gained funds, who ended up stuck in the system, some of it beyond our control, I think deserve an apology.
And would that apology come today from you, the Commissioner of the IRS, to them?
I would apologize for anyone, not just in this area, anyone who is not treated fairly under the code. I apologize to. Our goal is to make sure that taxpayers in all circumstances are treated fairly. They're treated the same way. It goes back to the issues about determinations for C4 cases. I've said from the start, I apologize there for anybody who got caught up in that delays. Taxpayers have to be comfortable. They're all going to get treated fairly, the same way as everybody else, no matter who they are, what organization they belong to, who they voted for in the last election. If you hear from us or if you're dealing with us, you should be comfortable you're going to be treated the same way and fairly as everybody else. And to the extent that the system makes mistakes, we should recognize those, and I'm comfortable. I'm sorry the mistakes happen if they happen, and I'm happy to apologize to say if taxpayers have gotten themselves into a situation that is not their fault. They are not consciously structuring. They're not avoiding taxes. There are a lot of people out there structuring to avoid letting us know what they earn. They weren't. If they paid their taxes, they weren't doing anything consciously illegal, and they got wrapped up in the system. That was a mistake, and I apologize for that.
So to be clear, it's your intention to have the new policy reduced to writing and part of the manual within the next quarter?
It'll be by the end of this quarter, and as I say, we've instructed agents already. This is a policy that has not been under, quietly done. It's been in the press. We've talked to our offices. Again, with Congressman Holding, if somebody is not following that policy, that's a mistake. And while we don't hold people and measure their progress by how much they collect, we do measure their progress by following our policies. We have terminated a large number of employees every year who don't follow the policies and procedures because we take them very seriously.
Once it's in the manual, the new policy, for example, would it be within the discretion of the next IRS commissioner? Let's say that that person had a different disposition than you. Would they have the authority to go back and revisit that and say, look, we're going to move back into this legal source approach?
You could do that.
So that would require a change in the statute
If
to remedy against that.
You've got me for the next 3 years, and then thereafter you might need to deal with this.
I just wanted to follow up on one thing that you mentioned to Mr. Meehan, and that was you said that we don't settle. We, the IRS, are not involved in the settlement process.
Unless you come in that short administrative period.
So what is that time period?
Somebody will tell me, but it's about 30 or 35 days. The statute is set up so you can come in administratively to the U.S. Attorney and the IRS. Otherwise, it goes, you file a claim in court. A large number of people go straight to the court if they're going to do that. The number of cases in 3 years, I asked about that. I think we've had 7 who showed up in that time frame making the case. And in fact, in 5 of them, it turned out there was evidence that there was a criminal violation, and so there was no settlement. So the discussions about people settling their cases and giving up large amounts are discussions that don't take place with the IRS as a general matter.
Commissioner, I think you've heard from both sides of the aisle here, and you've heard a great deal of concern. The stories that we're going to hear in the subsequent panel, and I know you have another commitment and you're not able to stay, but I would commend you to have your staff summarize those stories and their actual accounts, because the agency that you're now tasked with leading has basically come off like Inspector Javert. You know what I mean? With very little flexibility, very little concern, and as Mr. Rangel said, looking within the 4 corners of the document without looking at the totality of the situation. So I appreciate the exchange today and your willingness to come and spend time with the subcommittee, and we look forward to continuing a dialogue with you in the future.
Well, I appreciate it, and I appreciate the discussion. As I said, this is an important matter. We take it seriously. I think the concerns are legitimate and appropriate. It's part of what drove us through the policy that we will continue to follow and deal with. And I think taxpayers, as I say again, your point is there, need to feel they're going to get treated fairly and appropriately. As somebody earlier on noted, I do distinguish, and we do as an agency, if you're trying to become compliant across the board, we're anxious to work with you. You don't have to hire somebody off late night TV. We're going to try to work with you. It's the people who are consciously deciding they're going to cheat, they're going to avoid taxes, they're going to participate in criminal ventures that we should be applying our resources against, and we're trying to make sure that that's the division that's made. And so we are, as I say, we have a taxpayer bill of rights we went out of our way to provide to taxpayers to make sure that they understand that they are an important part of our process, and we take their rights very seriously. So I appreciate the discussion and the conversation.
Thank you, Commissioner, for appearing before us today. Members are advised that they may submit written questions to be answered later in writing. Those questions and your answers would be made part of the formal record of today's hearing, Commissioner. And as the Commissioner knows, I wrote seeking information about the IRS's contract with CGI. Thanks for the response we received on Monday, and I note that there's a number of items that are missing, including the documents requested. Would you and your staff be willing to work with us to satisfy the document request?
Yes, in fact, we hope to satisfy without any further work. It just takes a little longer, and I wanted to get a response back to you quickly, and we will get you all of those documents, and we'll make sure that your staff are comfortable that they've got everything you asked for.
Thank you. We'll now turn to our second panel. Thank you, Commissioner.
Thank you.
I want to thank you so much for bringing up these things that happen to innocent people. It seems as though the Congress gave them the authority to do these vicious things against people who never intended to violate the law. So even though your question is, could another commissioner change it, I think maybe on the suspension calendar, we could correct this to make certain that nobody without criminal intent be subject to this type of behavior. But I want to congratulate you for bringing it up.
Thank you. I think that there's a lot of interest, Mr. Rangel, on this issue across the spectrum, and I'm committed to working with you and others to make this right. Mr. Sowers, Mr. Hirsch, Mr. Clyde, and Mr. Johnson, thank you for your time today. The committee has received your written statement and it will be made part of the formal hearing record. You'll be recognized in sequential order and have 5 minutes to deliver your oral marks. Mr. Sowers, you may begin when you're ready.
Good morning, Mr. Chairman and members of the committee.
Mr. Sowers, why don't you pull that mic a little closer to you, and is the light on down below?
Okay, it's on. Good morning, Mr. Chairman and members of the committee, and thank you for inviting me to this morning to testify. Gets me out of the cold. I mean, do most of my work in the cold. It's kind of nice being warm a little bit. My name is Randy Sowers, and I'm a dairy farmer by trade. My wife of 40 years is here with me today. We started farming in 1981. Our parents weren't farmers. We started on our own. I have 1 or 2 children. One of them is still on the farm with us. We did rent a farm in Frederick County, and later on in 1987 got to buy that farm. Farming is a tough business to be in. Been many a time almost to the verge of not being able to make it, but we're here. 20 years after we started, we invested $1 million and built a processing plant. We process milk and home deliver it to more than 8,000 customers in the greater Washington area. So that brings us to why we had this cash we were depositing, because to promote ourselves, we would do farmers markets. That got us out there, give people samples, sold them our products, told them who we were, and we got a lot of cash at the time. We were doing 5 or 6 markets a week. In the beginning, the cash just got deposited kind of with the rest of the income from our business. This year, when it was 4 years ago, I think, I'm not sure about the date, but and we're vertically integrated. We do everything from start to finish. All of our animals we raise ourselves. We produce all of the milk, the meat, beef, pork, whatever we sell and distribute to the people. But this year, or 4 years ago, my wife went to the bank one day and she had $12,000 in cash because we do a festival. So we had a little bit of extra cash that week. And when she went to deposit, the teller told her, well, next time just keep it under $40,000 or $10,000. Now I don't have to fill out a form. So that's what she did. Not that it was normally more than 10. I mean, it was in that neighborhood, but she has to keep cash on hand for those 5 markets to have, cash to, or money to give people when we make change. So that's why it didn't all get deposited, and most of the time it wouldn't have been over $10,000. But we leave the markets we do now, we leave at 3 o'clock in the morning and go, but that's actually a late time for us because we usually get up 12:30 every morning and milk, and we've both been up milking cows every day since the 1st of November. So a 12-hour day for us is a short day. But anyway, we had the Treasury Department show up one day, and I thought one of these days they'd probably show up and wonder where I was getting the cash. I never thought about it. Our lawyer was there, and he had just left. I tried to call him back, and he didn't come back, so I didn't think it was a problem. I just talked to these people, and they did ask me questions, and the 2 agents were pretty good. I mean, I didn't have a problem with those guys. I think they saw right away we weren't criminals, and they pretty much said that. But he said, we took your money. I said, what? Yeah, we seized your money. And, I was really taken back with that. I couldn't believe that, they just come in and take my money with no prior, notice. And we thought it was going to be easy to remedy this thing because we gave them what they needed. I mean, my wife wrote down every week what we got from farmers markets, and that's how we reported it, and we turned that in. That's what they wanted, and they wanted some other things that we turned in right away. But it seemed like when my lawyer talked to the Justice Department that they thought, too, it wouldn't be a big problem, that we'd settle this thing, and, he would throw a number out, and we would throw a number out. And I was down at my neighbor's doing a job one day, and I got a call from a guy from Baltimore City paper, and he was asking me questions about this case because he saw it come out of the docks in Baltimore. And I said, well, my lawyer don't want me to talk to anybody about this, but he said, well, I'm going to do the story. It don't look good on your part, so it's up to you whether you want to tell me the story or not, because I was itching to tell somebody the story anyway. So I told him the whole thing. And he did a beautiful job in the paper of explaining what had happened. What seemed to be after that my lawyer was talking to the guy from the Justice Department, and things had changed then. He said, since, I went to the press, then we were different than most people when he was going to, we were going to have to pay what he wanted, and there wasn't going to be any question about that. So we finally settled for $29,000. I mean, they took 66. Actually, they took some more they weren't supposed to take, but that's where it ended, and we thought it was done. But after that, they did send the IRS out to talk to my accountant, asking him different questions that we didn't, understand. And my accountant said that they told him that he shouldn't tell me that they had contacted him. So I thought the government was supposed to protect me. I didn't think they were supposed to come out and try to put me out of business, because that's what they could have done easy enough. And we're just hardworking farmers. I mean, we don't have time to be criminals. We got 1,000 animals to take care of, and, we have to take care of them. And that's what we do. And we love doing it. That's why we do it. We wouldn't do it if we didn't love it. It's too tough a job. So I think the government ought to give me my money back. I want to thank my lawyers that did help and took a little bit of the pain away. I mean, it was kind of tough sometimes getting some sleep, and they could charge you with a felon as felons, and some people have been charged with that when they fought them.
Well, thank you, Mr. Sowers. That's very, very helpful, and we appreciate it. And I know that our members will have a number of questions for you and further inquire. Mr. Hirsch?
Good morning, Chairman and members of the committee. My name is Jeff Hirsch. And I'm the owner of Bi-County Distributors with two of my brothers. We sell candy, tobacco goods, and paper goods. On May 2012, we went to the bank that morning, and the teller said that our account was frozen. Me and my two brothers didn't know what was going on. We made phone calls. And finally, we got a letter later that day stating our account was seized by the IRS. So we made phone calls, and we called this Detective Kearns that was on the letter, and we asked him what's going on. We're doing nothing wrong. And he said to contact an attorney, because I asked him to come on down, take a look at my operation, and he wouldn't come down to take a look. So we contacted an attorney in New York City, and Mr. Toshnik, and he was working on the case for 2 years. And he was getting frustrated because he kept making phone calls. They gave him the runaround. We met with them twice with this district attorney, and it just looked like they were fishing for anything they could. And there was nothing there. So he advised me to hire a forensic accountant. So we did. We hired Baker Tilly in New York City, and they did our books for 2011 and half of 2012. And it came back with a clean bill of health. It was a 40-page report, and still they wouldn't give us back our money. It was getting very frustrating It's been 2 years and 9 months. We finally settled with them, with the IRS, January 20th of 2015. They're giving us back all our money, and as of today, we haven't received it in the bank account. So we're still waiting. But in the meantime, they were just, in the 2 years, 9 months, just giving us the runaround. And after 2 years, Mr. Potashnik just didn't know what to do anymore. And we found the Institute for Justice, and they handled our case. It's just, and it's an embarrassing moment when you got to go to your vendors and you ask him to extend you more credit for the week. And I've been in the business 27 years, so they all know me. They know what type of business we're running. We know we're honest people. So a couple of them been helping us out through the 2 years and 9 months. And we still owe these people money. So the money that we're receiving from the government will be going back to these vendors. So I just hope that nobody in this country or person has to go through something like this. It's embarrassing. It's really can't put a word for it. It's just been a long 2 years, almost 3. Thank you.
Thank you, Mr. Hirsch. Mr. Clyde?
Thank you, Chairman. Honorable members of Congress, thank you for the invitation to tell my story. I'm Andrew Clyde. I own Clyde Armory, which is a small federally licensed firearms store in Athens, Georgia. On Friday, April the 12th, 2013, 2 IRS agents showed up at my door and served me with a seizure warrant saying that they had already taken $940,313 from my company's bank account that morning, which was most of what I had. I started Clyde Armory in my home in 1991. I worked hard and put in long hours to grow the company. I hired my first employee in 2002, and today we have 25 employees. I have been blessed to live the American dream. In 2003, I made my first combat deployment to Iraq as a Navy Reserve, and those employees carried the business while I served. In 2004, I obtained my first insurance policy. That policy had a $10,000 cap for covering my loss of cash outside the business. Today, my insurance policy has the same $10,000 cap. To reduce risk, my company policy on carrying cash to the bank mirrors my insurance policy. In late 2012, the President proposed new gun laws. During the following 5 months, we experienced incredible sales, with much of it being in cash. That meant we took in over $1 million in cash. We also held to my company policy of not depositing more than $10,000 in cash in the bank at any one time. At the IRS agent's deposition, he acknowledged that there was no floor for a structured transaction. That meant any deposit under $10,000 could be considered structuring. For us, it was as low as $1,628. When the agents visited me, I had no idea what the term structuring even meant, and I had no knowledge that there was a law that prohibited structuring. The agents educated me on structuring and also told me that it was a felony. A felony? Yet, if they were right, I would lose everything I'd worked for, because you cannot have a gun business and have a felony. The seizure had the potential to devastate me. The timing was 3 days before April the 15th, when my 2012 taxes and 2013 estimated taxes were due. After I had paid both tax bills and my next employee payroll, I had no money left to run my business. By the grace of Almighty God, I was able to borrow $80,000 from my banker at Wells Fargo to keep my business alive. I immediately canceled the product orders that I could and also canceled a new computer system. If the business did not survive, then neither would my employees' jobs, and they had families too. At the initial meeting with the government, which was 6 days later, my accountant and attorney showed them that this was all legal money and properly reported. But the government already knew the money was clean, but that didn't matter, because in their interpretation of the law, it makes no distinction between legal or illegal cash, and the government wasn't going to give it back, not at least without their cut. On May the 7th, in an email to my attorney, the government said, and I quote, I have authority to resolve this case by forfeiting $325,000 to the United States and returning the balance to your client. This offer to resolve the matter already takes into consideration Mr. Clyde's contention that the cash was legitimately earned and that appropriate withholdings were made, two matters that we will not challenge. Despite acknowledging in writing the cash was legitimate, the government still attempted coercive tactics, saying that I could be criminally prosecuted for the misdeed. They also said that if a suit was filed, it could ruin my reputation in the community, and that if anything was found out during discovery, it could easily change to a personal criminal case against me. The clear intent was to force me to cave, and I refused. Again, by the grace of God, we got a hearing on July the 22nd, and the judge exercised creativity to force the government to return $440,000 of my funds. While the amount allowed me to immediately buy inventory for the hunting season, it was not a long-term fix. I needed the remaining $500,000. 3 days before the trial, I forfeited $50,000 to settle the case. It was my tactical retreat so I could live to fight another day. I did not serve 3 combat tours in Iraq only to come home and be extorted by my government's use of civil forfeiture laws. But that is what I feel they have done to me, and I need you to stop it from happening to anyone else. When I asked the U.S. Attorney why he was doing this, his response was, "I'm just following the law." So he laid the responsibility right at the feet of Congress. So I'm here to ask you to change the law and prevent them from ever going after legal source money again, and then restore those of us who have been abused. Honorable members of Congress, you are our last remaining line of battle. Thank you for the invitation to tell my story.
Thank you, Mr. Clyde. Mr. Johnson?
Thank you, Chairman Roscom, Ranking Member Lewis, and members of the subcommittee. Thank you for inviting me to testify today about the IRS's use of civil forfeiture to take money from honest, hardworking small business owners. Nothing I can say can speak as powerfully as the stories of the other members of the panel, but I want to begin by putting their stories in some context based on information that we received from the IRS through a Freedom of Information Act request. Between 2005 and 2012, the IRS seized money under the structuring laws in 2,500 cases. The IRS seized $242 million from Americans under the structuring laws. And in a third of cases, the IRS reported that it suspected no criminal activity other than the mere act of making sub-$10,000 cash transactions. Now, the Commissioner referred in his testimony to protections that are available by law. But those protections are less robust in practice than the Commissioner may believe. It is true that before money can be seized, it's necessary for a law enforcement officer It's true that it's necessary before money can be seized for a law enforcement officer to fill out an affidavit. And this affidavit is often filled out by local law enforcement officers working as part of joint task forces with the IRS. They're exercising federal law enforcement activity, that's law enforcement authority that's been delegated to them by the IRS, but these are local police officers filling out these affidavits. And what they will allege in the affidavit is a mere pattern of sub-$10,000 deposits. And that's the only information that's in the affidavit, the mere fact that there is a pattern of sub-$10,000 deposits over a period of time. Before bringing that affidavit to court to seize property, they give no warning to the property owner. There's no notice that the property may be seized, and there's no meaningful investigation that's conducted to determine if there might be some legitimate business practice explaining that pattern of sub-$10,000 deposits. Now, when that warrant application is brought to a magistrate judge, that's an ex parte proceeding, meaning that there's no opportunity for the property owner to present a defense, to explain why they might be depositing money in the bank in amounts under $10,000. In many cases, people have all kinds of reasons that they're depositing money in the bank in those small amounts. It may be the case that there's an insurance policy that only covers up to $10,000. Or in many cases, people simply are told by their own banks that sub-$10,000 deposits are easier for the bank. They avoid paperwork burdens. Banks may even close people's accounts if they make frequent deposits over $10,000 because that creates a burden for the bank. So there's no serious investigation to determine whether those explanations may be present, and there's no opportunity to present that defense at the hearing before the seizure. Finally, once the seizure has happened, property owners simply must wait. The law does establish deadlines, 30 days, 60 days to file an administrative hearing, and then 30 days after that you can file a claim. But those deadlines are routinely disregarded because the law provides no meaningful enforcement mechanism to ensure that they are actually followed. Because if the government doesn't follow them, although it's required to return the property, that's without prejudice to taking the property again at a later time. The reality as a result of this is that property owners simply are forced to settle. Some statistics that underlie those facts. Of the $242 million seized between 2005 and 2012, $116 million of that was not forfeited by the IRS. And what that means is that the IRS is seizing substantial amounts of money that it ultimately cannot justify keeping. The commissioner also mentioned the policy change. I think it's important to underscore that that policy change includes this loophole for exceptional circumstances. And the commissioner made clear that it will be considered exceptional if there is a pattern of deposits over a long period of time. And that's something that we see in almost all of these cases. So almost every case here today, I think every case here today, would qualify as exceptional under that new policy. I thank you for inviting me to testify and welcome your questions.
Thank you, Mr. Johnson. On the majority side, we'll go to Mr. Margent.
Thank you, and thank you for traveling to Washington today and sharing your story with each one of you. I think what I'd like to do, many of you have already discussed some of these facts in your opening statement, but if you would go down the line, starting with Mr. Clyde, and answer the following questions. How much money did the IRS take from you? How much did you get back? How long did it take you to get back? How much money did you spend on lawyers and accountants?
Okay, sir. They took $940,313 from me. It took me right at 5 months to finally get it back. At the 4-month mark, we had a judicial hearing, and I got $440,000 back. And then right before the trial, because the judge gave me an expedited trial, because that was the only way he could get me money back was through an expedited trial. 3 days before the trial, I gave up $50,000 to get my other $450,000 back. It cost me, including the forfeiture, the $50,000 forfeiture, in pre-tax income, it cost me $149,336 to defend myself.
Okay, thank you. Mr. Hirsch.
They took $446,000 out of the bank. It took us 2 years, 9 months to get it back, and we're still waiting to get it back. We settled with them. We didn't have to give them anything because we did nothing wrong. We proved that. And what was the last? It cost us between accounting and lawyer fees about $60,000, and also we had to break a $50,000 CD to keep the business running, and we had to lower our inventory so we could keep this business still going.
Thank you. Ms. Sowers.
It took around $62,000, but at the time they told me that I could use that account and nothing would happen to it. But my wife had made another deposit of $5,000 after that, and the bank sent that to him too. So I guess it was actually $67,000. I don't think it took much more than 4 or 5 months to get back. I don't remember. It's been 4 years ago. I know at that time of year our sales are down in our home delivery businesses, and we're putting out crops, so it was kind of tough not having it. But people know me, and in farming sometimes they'll hold off for their money. So we did all right on that one. My lawyer I have on a retainer anyway, so he pretty much had to do the work because we already paid him. But Anyway, our accountant, I'm sure he charged me for what he did, which wasn't much because we had the information they needed to show that what cash we actually were taking, and we weren't evading taxes or anything like that.
So did each one of you, just the mechanics of this, you then had to go set up another operating account in your bank. You couldn't continue to operate that account. Did they close your physical bank account down or just take the money out of it?
They just took the money, sir.
So you could immediately go back to that same account and continue to do business out of that same account.
That is correct. We could.
And the same with all of you.
Same.
Well, actually, the account we were depositing money in was in a different bank than we normally use, and for some reason that summer it seemed like we were doing a little bit better, and we were trying to put some money back, so we were putting it in that account, trying to, hide it a little bit. So it wasn't our main account. If it would have been, we would have been out of business because there was probably $168,000 to $200,000 on that account, which we pay employees and everything else out of. So it actually was good that they.
Were you given assurances by the IRS that you could go back and continue to make deposits and they would not be back a week later or a month later to do exactly the same thing?
No, sir, I had no assurances of that. In fact, I asked them that exact question. What prevents you from doing this? Nothing.
So it was very disruptive to your business,
Incredibly.
to your psyche.
Yes, sir.
To know that you, in fact, a lot of people would respond exactly the opposite and then try to arrange things where they could not find the money and seize it, which seems to be very counterproductive.
Mm-hmm.
Thank you, Mr. Chairman.
With leave of Mr. Lewis, we'll go to Mr. Crowley.
Thank you, Mr. Chairman. Thank you, Mr. Lewis. Firstly, let me say that I have great empathy for all of you and what you've gone through. Mr. Hirsch, I was going to offer to interpret for you, for my colleagues, given that wonderful New York accent. But, you seem to have pulled it off on your own. In your testimony, you made reference to the fact that the IRS began an auditing of your business in the middle of your dispute with the IRS. Is that correct?
Yes.
Can you put your microphone on? I don't know if it's
when we were trying to settle this, the 2011 case in July 2014, they decided to audit my 2012 books, which they already knew that half the year was already done through the forensic accountant and came out with a clean bill of health. So it's like a little salt in the wound. And we're still going through that today, and everything looks like it's going good on it.
So the audit is continuing. In other words, the IRS continues to audit you,
Yes.
even though they've come to settle with you, and they're going to they indicated to you they're going to return to you the monies that they took from you. Correct?
Right. So they're auditing the next year. So it was 2011. They took the money they took. So 2012 is the audit right now.
I thought it was an interesting question what my colleague asked, and I had a similar question. That was the expense that it cost you. In other words, you said it was about $60,000?
Yes.
Overall, including in terms of the CD loss and the penalties paid and
That was without the
attorney's
CD.
Attorney's fees?
The attorney's fees and the accountant fees came to about $60,000. And then there was the loss of the CD, which was $50,000.
And you had to lower your inventory, and that
Yes.
had an effect on your business itself.
Yes,
right?
it made
So
it
you're-
work a little harder. We put in a 12-hour day right now, so instead
Which
of 12
affected
hours,
your profits and your ability to employ people.
yes, we have a part-timer. So it's me, my two brothers, and a part-timer, 4 of us.
In regards to what you said the IRS took and what they have agreed to repay you, you have yet to receive that money back. Is that correct?
Right.
Have they given you any indication of what date you ought to expect receiving that money back?
No, not as
So
of yet.
really, in theory, they've indicated they're going to give you the money back, but they still hold on to that money.
Right.
And you are not receiving any interest, nor is the company receiving interest on the money they're holding from you right now.
No, we had to sign an agreement with them that we wouldn't collect any interest on it.
Okay. I think that's something of interest as well, I think, to the committee as well. as I said, I have empathy for you all. Mr. Sowers, my in-laws are from Montana. You remind me very much of folks, their farming family and ranching family remind me very much of those folks as well. And you describe the work as hard, arduous. It's something you love, and it's what keeps you going. So I appreciate what you do, what the American farmers do for our country. And I don't think you nor any of the gentlemen before us today deserve to be treated by your government, by the IRS, in the way in which you have been. I think, Mr. Chairman, we should also look at the possibility of when someone who's innocently accused and wrongfully, monies are wrongfully withheld, and it's been adjudicated, and the IRS has been found without cause to having held their resources, that the responsibility ought to be on the government to pay not only back the resources withheld with interest, but also any legal fees that those individuals went through, because that could that in of itself can decimate a small business. As the gentleman, Mr. Clyde from Georgia, had mentioned, the ability to pay and make payroll, the ability to do everything one has to do to maintain a business. That is something I think we should be looking at as well in terms of any legislation moving forward. I'd be happy to work with you on that as well. And I thank the gentleman for giving me the time.
Thank
you all.
That's a great point, and it's, the irony is the IRS charges interest.
Yes, sir.
Mr. Kelly's recognized.
Thank you, Chairman. I thank you all for appearing. Mr. Sowers, you look like a lot of the people that I represent back in Western Pennsylvania. And Mr. Clyde, I hear the way you're talking about what happened to you and Mr. Hirsch. There's a family called the Logan brothers that did the same type of a business in my town. They've all passed, but they were very big in our town because they just constantly reinvested in the community and did a lot of things from a charitable standpoint. But I think the real story here today is how it affected you as an American citizen. You've been violated by your government, and something that you've trusted in all your life and thought to be true, all of a sudden you find out that those same people are the people now that are coming in. I think sometimes the confusion is who do we represent? I do not represent the United States government. I represent 705,687 people from Pennsylvania's District 3. I don't know if they're Republicans or Democrats, independents, or people say, I don't care, just leave me alone. I've watched you. The Harpster family up near State College does what you do. I get so many people that do what you do. I'm an automobile guy. And one of the things that I went through was having a dealership taken from me by the government, not because I couldn't meet the standards, not because I didn't have the money, but because they decided to do that. It cost me $60,000 and over a year of not being able to sleep and then going through cash for clunkers where the government was holding $700,000 of my money, but they said, well, we'll get it to you when we can get it to you. That was all money that I had to use to pay off my lender because the product that I sold was collateral and had to be paid in full. Just from your experience, wouldn't you like to just sit across from somebody or somebody that comes in from the government that talks to you that has actually walked in your shoes as opposed to saying, look, I'm just following the law? I mean, this is an incredible violation of you as an American citizen. And I get tired of people coming in from government agencies, oh, no, listen, you don't understand how it goes. I said, I do understand how it goes. You don't. After what you've been through. Now, you talked about how much money you've lost, but what about your loss of faith?
Loss of what?
Faith and belief.
I don't deposit cash in the bank anymore.
You, Mr. Sowers, if you came in, the people that I represent back home, you know what they'll come in? They'll come in and buy a car and say, you know what, Kelly, talk to the wife, we can afford about $225, $230 a month. What would I have to put down to keep that payment there? God help me if I say to them, you know what, you got to put down about 12 grand in cash. They'll say, so if I put down 12 grand, I can save about $2.25, $2.5. Yeah, you can do that. You know what I've just helped them do? I'm involved in structuring. By you coming to me and telling me what you can afford and me telling this, you know what I got to say, hey, listen, you know what, Sowers, you kind of do what you want. You know where the payment is, and I can't tell you this at the time. If you come in and you give me a check for 10 grand or give me cash for 12 grand or whatever it is you give me, and I put it towards the deal to structure a deal that makes sense for you and the missus to meet all your obligations, I've got to file this form 8300, which is affectionately called, this is incredible, a suspicious transaction. I'm going to tell the United States government, I got a dairy farmer who wanted to keep his payment down, and I didn't really tell him. I told him, you know, at some point I probably have to report this, but I got almost a year to do it. But you go ahead if you want to do it, but I can't say that I help you with that. I mean, I don't know that the general public understands what it is, and I understand. Listen, I've been in front of Mr. Koskinen before. If you've never been in that person's shoes, you have no idea. Between sleepless nights and wondering about how you're going to meet your obligations. Now, you all were able to go to your lenders. Why did they extend your credit? Because they knew you.
That's right.
Isn't it amazing that the people that you do business with every day know you and trust you, but your own government does not and is willing to shut you down because of a suspicious transaction?
Yes, sir, that's correct.
Absolutely incredible. But what I go back to is I think the main loss here is a loss of faith and trust we have in a form of government that is the gold standard for the world, but yet we're violating our own citizens on an everyday basis and asking them to say, hey, listen, still believe in me, still believe in me, still believe in me. You got to feel like David going against Goliath, and you talk about how, you know what? Mr. Clyde, what do you have? The IRS has unlimited resources to fight you. You're limited by what you can do. So when they come in and say, listen, we're going to work with you on this, what you had to settle for, you had to give up money to get them off your back. You know why? Because as soon as it starts, the meter's running. And I've dealt with a lot of great lawyers who've helped me through a lot of great problems, but it's always been at my expense. Their time, my money. I applaud you for coming, and you know, most people won't do what you're doing. In fact, my son's back home running the dealership right now. He says, for God's sake, Dad, quit talking about the IRS. Next thing you know, they're going to be in here. I say, hey, Brendan, if they come in, that's okay. We'll still fight them tooth and nail. I had a fight to get the damn dealership back from the government to begin with, and we already were meeting all the expectations. So I know what you're doing. I know how you're fighting. I know where your hearts are. I thank you for coming here today. You are truly brave people, and you are the real patriots. Thank you.
Thank you.
Ranking Member Lewis is recognized.
Well, thank you, Mr. Chairman. Mr. Chairman, I want to thank all of the witnesses for being here today. Thank you, as the previous speaker said, for being courageous and being very brave to be here. I know you're taking time from your work. You're hard-working, very busy people. Mr. Clyde, I see that you're from the great state of Georgia.
Yes, sir.
I want to welcome you from a great city, Athens,
Yes,
where
sir.
the University of Georgia is located. Mr. Sowles, I know you're a great farmer. I grew up on a farm. I'm very sympathetic toward the predicament you find yourself. I grew up on a farm that my father bought in 1944 when I was only 4 years old, but I remember. He bought 110 acres of land for $300, and we still own that land today. It was very hard work, gathering peanuts, picking cotton, pulling corn, and I used to fall behind when I was out there picking the cotton and gathering the peanuts, and my mother would say, boy, you're falling behind, and I would say, this is hard work. And she would say, boy, hard work never killed anybody. I said, well, it's about to kill me. Now, also on the farm, it was my responsibility to care for the chickens. And I fell in love with raising chickens. And as a little boy, I wanted to be a minister. So from time to time, with the help of my brothers and sisters and cousins, we would gather all of our chickens together in the chicken yard. And my brothers and sisters and cousins would line the outside of the chicken yard, and I would start speaking or preaching to the chickens. And so I'm interested in knowing, do you raise any chickens?
I have 17,000.
My God. Oh. That's a very large congregation. I know you don't try to baptize any of those.
Maybe.
Yeah.
Our
So-
chickens are certified humane, free range, everything everybody wants.
Well, that's wonderful. Let me just ask you, have anyone from the IRS, except for today, have anyone, Mr. Clyde, Mr. Hirsch, Mr. Sauer, ever said, I'm sorry, we made a mistake, we made a blunder?
Like I said, the two agents that showed up, I think they were apologizing a little bit. They knew what was coming down the line, and even though they knew there was no intent, but they said, now that it's this far, it's got to go the rest of the way. They didn't say they were sorry, but I think they were, you know, they knew what I was going to have to go through.
Mr. Hirsch?
No one ever said they were sorry to us.
Mr. Clyde?
No, sir. No one ever said they were sorry to me.
Well, as one member of Congress and a member of this committee, I want to apologize to you for what a piece of our government, what the IRS did to you. I wish you well. I don't have any questions, Mr. Chairman.
Thank you.
Mr. Meehan is recognized.
New appreciation for the foul conduct of the IRS, I guess, huh? Mr. Clyde, I was sort of struck by your testimony. You've served our nation in the armed forces.
Yes, sir.
You took how many tours overseas?
3 combat tours, sir.
Do you have family, Mr. Clyde?
I'm single, but yes, I have family,
So
mom
your
and
family,
dad.
you left
and
family back here operating the business while you were overseas.
Actually, it was just my employees that operated my business.
When you returned and you took this position and then you identified what went on with you, when the IRS agents came to speak to you and the U.S. Attorney's representative came to speak to you, you described that you were leveraged in your negotiations.
Oh, yes, sir.
Can you explain to me what they said to you?
Yes, sir. They told me that, in fact, it's in the court transcripts. They said that discovery hadn't been made yet, okay, and if they found anything in discovery, that it could easily transition from a civil forfeiture case to a criminal case against me, and that came at least twice. If after the first, after each offer, actually. The first offer of taking only $325,000 as a forfeiture, and then the second offer after the judge forced them to give back $440 to me. Then the IRS offered to settle. Well, now only for $109,000 this time. Both times the comment was made, and if we find anything else in discovery, because discovery hadn't happened yet, that we will. We can go against you criminally, absolutely.
Did you feel like a criminal?
They made me feel like a criminal, but there's no way I'm a criminal.
If you resolved the case, did you have a concern that there may have been people that believed you were a criminal?
Absolutely. Yes, sir.
Did you ever talk to anybody in a supervisory capacity when you were being leveraged in that manner in the U.S. Attorney's Office about their demands that you consider that implication and resolve the case?
The only contact we had with the U.S. Attorney's Office was through one of the assistant, or really 2 of the assistant U.S. attorneys.
Well, it's reprehensible activity, Mr. Clyde. It's a violation of the Code of Ethics to be calling you a criminal to leverage a civil proceeding.
Wow.
And they did you wrong. But, Mr. Johnson, you have walked through this process with numerous of these people as an attorney who understands what needs to be proven in a circumstance like this to suggest that somebody's violated a structuring crime.
Well, I think that's an important question because the law really does demand something more than a mere pattern of deposits. The structuring law applies to people who have a purpose of evading the bank reporting requirements established by the Bank Secrecy Act. And I don't think anybody on this panel had that purpose. I don't think anybody in this panel actually violated the law. You know, the IRS is pursuing them anyway. It's true that the structuring law contains very few protections for property owners and can sweep up people who do not know that it's illegal to try to hide something from the government and are hiding something simply because they don't want the government.
So there's no mens rea, so to speak. It's just
Right.
This is a strict construction of the fact that you just did this act. They don't have to demonstrate that you were trying to elude some oversight by virtue of doing it?
The people who get swept up by the structuring law, who actually may be guilty of structuring, but who most people would say have done nothing wrong, are people who simply don't want the government knowing what they're up to. And in most people would say that's not a crime. But under the structuring law, that actually is a crime, and these people have no idea that they're even potentially breaking the law. But again, the people on this panel, that's not even their case. These are people who literally didn't even want to hide anything from the government.
Mr. Chairman, I have just a couple quick questions I'd like your response to, just so we can create a record. There's something called the Civil Asset Forfeiture Reform Act. It requires a response within 60 days. From your experience, does that happen?
No. In my experience, the government routinely disregards the deadline set by the Civil Forfeiture
Notwithstanding
Reform
that
Act.
there is a law that requires that that be done within 60 days, the Enforcement Act.
Yes. The problem is that the law simply does not provide any penalty for the government if it disregards those deadlines, because any penalty that's provided is simply toothless.
The law contemplates hardship hearings in circumstances in which it's available to individuals that are targeted under certain structuring laws. Are those available to somebody who deals exclusively in cash?
No.
So you may have a circumstance in which, again, the hardship opportunity is not available to you because you run a cash business.
Right, that's absolutely right. The hardship hearing would be available for any kind of non-cash seizure, for most kinds of non-cash seizures, but the law specifically says that there's no hardship hearing available if if it was cash that was seized.
Certain procedures here have been identified by the IRS commissioner in which he said he has told prosecutors and others that they may not bring these cases. But we have seen evidence that affidavits don't necessarily have to come exclusively from federal prosecutors. They may come from state police officers. They may come from local police officers. Is that accurate?
That is accurate, and I think another important point to make is that those state and local officers have a financial incentive in the enforcement of the law, because under what's called equitable sharing, up to 80% of the money that's seized by the federal government can be returned to local law enforcement agencies.
Do you have to secure a conviction to get the cash?
No.
Mr. Chairman, thank you.
Mr. Holding.
Thank you, Mr. Chairman. I thank the witnesses for being here to tell your story. It's incredibly important that the people know. Mr. Johnson, right now, if the IRS seizes your client's money, you can't get into court immediately to fight the seizure, correct?
That's right. People have to wait months or even years. In Jeff's case, the government held his money for over 2.5 years and never gave him any hearing before any judge.
Yeah, I was doing a little calculation, 974 days.
Yeah.
That's a long time.
Long time.
And they still haven't given it back to you.
No, not yet.
Last year, former Chairman Camp and Ranking Member Levin introduced a bill that would allow people whose assets have been seized to contest the seizure on an expedited basis within 2 weeks. I'm sure the victims here today would have wanted to be able to go to court, in that expedited manner and contest their seizure. So you, Mr. Johnson, as an attorney, representing folks who are in this predicament, do you think this would be an improvement over the current procedure?
I think it would absolutely be a major improvement to allow people the opportunity for a prompt hearing, both to contest the seizure and also to present evidence of hardship.
And also, per the commissioner, perhaps evidence that a predicate illegal act hadn't been committed under his new policy.
Yeah, I think it's important that the policy be codified into law so that it actually would be a defense in such a proceeding. As it stands, as the members of the commission have noted, it's simply a discretionary matter with the IRS. Also, as I was saying earlier, the exception for exceptional cases is so broad that it really makes the policy potentially meaningless in practice.
So in addition to codifying that affirmative defense, can you think of some other ways that the law should be reformed in order to protect against abuses by the IRS of folks such as we have here today?
I think one of the most important reforms that could be made would be to eliminate the profit motive that's inherent in civil forfeiture. When the IRS seizes money, that money goes into a dedicated fund that is then available to the IRS without any congressional appropriation to fund law enforcement expenses. And what this means is that the IRS is seizing money from innocent Americans, and it's using that same money to fund additional seizures. And this creates a clear incentive for abuse by the IRS. And at the same time, through equitable sharing, that money also can go to local and state officers who are involved in the seizure, giving those officers a profit incentive as well. So I think that eliminating that profit incentive would be a major step towards reforming this area of the law.
And we should point out that the majority of seizures are from criminals at the end of the day. What we need to protect against are these instances when the IRS or another form of law enforcement overreaches and ends up catching within a web people who haven't done anything wrong. And
I think that's true, although I would again emphasize that of the $242 million that was seized by the IRS under the structuring laws, $116 million, so almost half, was never forfeited. And what that suggests is that the IRS is seizing substantial sums that it ultimately can't justify keeping in a court of law.
Mr. Chairman, I yield back.
Mr. Smith.
Mr. Johnson, just real quick, you well in the Institute for Justice that was released in a report just recently, it said 59% of the seizure cases were actually valid, I guess. So what I'm interested is the other 41%. What's been do you have statistics showing how fast the 41% was returned in a timeline or anything like that?
We don't have statistics on how long it takes for the IRS to give people back their money, but I think that just based on experience, it can take a very long amount of time. In cases that we've litigated at the Institute for Justice, it took Jeff 32 months to get his property back. Carol Hinders, it took 18 months. For Mark Zanuski, who owns a service station in Michigan, it took 8 months. And for Terry Deco, who owns a supermarket also in Michigan, took 11 months. So we're talking about months, if not years, in which business owners are forced to go without the working capital for their business. Those are months or years that people simply may not have, which is why so many of these cases end up settling.
Could you put a number on how many businesses have been shut down because of the IRS's actions?
I just don't have that information, but I think that it's probably substantial.
Thank you, Mr. Chairman.
Ms. Noem.
Mr. Sowers, you're a man after my own heart. I've spent my life in farming, so, but we did crops and cattle, beef cattle, so you work harder than we do. Dairy cattle are a lot of work. So I appreciate you taking the time to be here, and I'm glad to see your families and business with you. That's I was completely formed by all the hours I spent working alongside of my dad, and that's a blessing to have. But Mr. Johnson, I just wanted to ask you a couple of quick questions. Do you believe that the IRS's new policy is good enough?
No, I don't believe that it's good enough, and I'd say that for a number of reasons. One is that the policy contains this loophole for exceptional circumstances, and previously what I would have said is that is troublingly undefined. After the commissioner's testimony today, I would say that the actual meat that he put on the bones of that exception is even more troubling. He said that a long-term pattern of sub $10,000 deposits would be considered an exceptional circumstance, but that really is the norm in structuring cases. When people have reasons to deposit under $10,000 because, for instance, they have an insurance policy that covers only up to $10,000, that's something that they will do over a long period of time. And there's nothing exceptional about that. I think it's also important to note that the policy only covers the IRS. And as the commissioner stated, there are other agencies that enforce the structuring laws, and those agencies are not bound. So I think it's very important that that policy be codified into law to bind the IRS fully without any exception for, quote, exceptional cases, and to bind other agencies as well.
I agree. And do you believe it should be retroactive?
Absolutely believe it should be retroactive, yes.
How far back do you think it should go?
I think it could go back as to the beginning of these kinds of cases. Forfeiture in structuring cases has only existed since 1992, so this has been around relatively recent.
Yep. Thank you. I will yield back.
Thank you very much. Mr. Johnson, Ms. Noem inquired of the commissioner in the earlier testimony regarding the motive of agents and so forth. And he was, like, look, don't worry, they're not motivated by some evaluation and so forth. But what you've testified to is something far more powerful, far more motivating, and far more insidious. That is a profit motive. Could you highlight that?
Absolutely. So when the IRS seizes money, that money goes into an account, the Treasury Forfeiture Fund, and then that money is available to the IRS to fund their law enforcement activities by federal law. And so the IRS has access to this money that otherwise they would have to come to Congress and obtain an appropriation. And, they might or might not be able to get that. Whereas if they seize the money, they can circumvent that entire process and build up their budget without having to come through Congress. And that obviously is incredibly attractive to the IRS. It's also a problem at the state and local level because of the equitable sharing process. You have local...
How does that work, equitable sharing?
Sure. So what equitable sharing is it means that when the government seizes property, and there's participation by state and local officers, as there generally is in structuring cases, because these cases are investigated and pursued by joint task forces of state, local, and federal officials. Then the state agencies that are involved can keep up to 80% of the money that's seized. And for a state and local law enforcement agency that may have difficulty otherwise getting access to federal funds, that's an incredibly powerful incentive.
Carol Hinders was one of your clients, or is one of
Yes.
your clients?
Yes.
I've looked at the affidavit that was sworn out in her case, and I'm amazed at how de minimis these claims are. So the person that swore out the affidavit says, they're asserting their expertise. My education includes a bachelor's degree in sociology from the University of Iowa. Hey, God bless the sociology majors, but you know what I'm saying? And there's other things, and I'm obviously kind of over characterizing this. But then there's these assertions about deposits that they don't look nefarious at all. They look like this is normal business transactions. You're familiar with this document, I assume. Can you speak to that at all? How do the affidavits strike you that you've seen? And then can you give a little bit more color commentary on the ex parte communication? In other words, you're not able, the defendant in this case is not able to assert themselves at any time until there's a trial, presumably.
Right. So unfortunately, I don't think the Carol Hinders affidavit is all that unusual. And there's a couple things about it that you pointed out that I think are pretty common. One is that it's filled out by a member of state or local law enforcement who may have very little real background in investigating these kinds of offenses. The commissioner spoke about how the IRS-CI is, one of the most respected...
Criminal investigations.
Right, is one of the most respected investigative branches. But in the structuring area, really these cases are being investigated and pursued in most cases by state and local officials who may have very little background in this. And then in terms of the bare bones allegations, that's very common. What you see in these affidavits that are being brought before magistrates to justify the seizure is literally, here is my training, here is what the law says, and then here is a list of transactions taken from a bank statement, all of which are under $10,000 in some amount. And then that is considered to be sufficient to give rise to probable cause, which is a very low standard, to then seize somebody's entire bank account. And again, as you know, with the ex parte hearings, when that warrant is brought before a judge, that affidavit is brought before a judge, there's no opportunity for the property owner to say, hey, wait a minute.
There's nobody else there, right?
Yeah, there is nobody else there. It's just the
Here's the paper, Your Honor. This is what I'm asserting. I'm the Soch major from Iowa.
Exactly.
I saw it.
What would be incredibly valuable, obviously, to any property owner would be an opportunity to say, look, sure, there's a bunch of $10,000 deposits, but I've got an insurance policy. It only covers up to $10,000, presented with that, what may look suspicious turns out to just be business as usual. But there's no opportunity for anybody to say that to the judge before the seizure occurs.
In the commissioner's testimony, Mr. Johnson, in his written testimony, he talked about a 93% conviction rate, which, if you read that, you think at first blush that's pretty impressive, 93%. we're in a 51% business as politicians, so 93% is a big number for us. But that doesn't really tell the whole story, does it?
No, it absolutely doesn't. So of the seizures, the $242 million that was seized between 2005 and 2012, as I mentioned earlier, $116 million was never forfeited. That certainly doesn't sound like a 93% rate. That's much closer to a 50% rate. In half of cases between 2005 and 12, some portion of the money ultimately wasn't forfeited. So again, that means you're much closer to a 50% rate. Many of those cases are probably settlements. These cases aren't going to trial. So when he refers to the 93% rate, I imagine he's referring to cases that actually go to trial. And actually, in a third of all cases where the money was seized for structuring between 2005 and 2012, none of the money ultimately was forfeited. So the IRS took the money, may have held it for months, years, and then ultimately determined, as they did with Jeff, look, we don't actually have a real case here. We're going to have to give this money back. But meanwhile, they've turned people's lives upside down, made their lives incredibly difficult for a long period, and maybe even put businesses out of business.
Mr. Hirsch, you haven't been able to get your money back yet, right?
Not yet.
Why not?
We're still waiting. We settled with them January 20th, 2015, and my lawyer right next to me, we're still, they said they have up to 60 days to put it back into the account.
And they just happen to have an audit interest now in you? You're just such an interesting person and such an interesting business that of all the fruited plain, of all the businesses that are out there, they've said, hey, let's see what those Hirsch brothers are up to. Is that basically what you're dealing with now?
That's what we're dealing with now. And in the 27 years that we've been in business, we pay our taxes, do the right thing, and we've never been audited before.
Never audited before. Now you've come under their scrutiny. You've won basically on this thing. You're going to get your money back. And in 27 years of business, they have never audited you, and now you're incredibly attractive to them, and they're all over you. Is that right?
Right.
Mr. Sowers, what happened? How did the government react when you talked to the press?
Well, my lawyer talked to the guy from, I guess he's what do they say, prosecuting these cases, the prosecutor. And when they gave us a $29,000 settlement number. And then my lawyer says, well, we think that's a little high, we're thinking about 5,000. And then he said, well, that's not in the cards anymore because your client talked to the press and, now we're going to have to do something different. But actually they told us, and I asked my lawyer about that this morning, and I'm sure it came up, if we would have went to trial, they would have went after the whole $360,000 that I had deposited in that account over that 32 weeks. So that was another scare tactic to say, okay, you want to go against us, we'll just take it all, not $29,000.
So they're up in the ante because you talked to the press.
That's what we figured, and we do have a.
Oh, it's not complicated. I don't think your calculus
We actually
is
have
off.
an email from him to my lawyers stating that.
Really?
Yes.
Who is that from?
I believe it's from Stefan Casella.
Yes, that's the guy.
A U.S. attorney.
And he disclosed. Or tell me about the email. What was the nature of the email?
There should be a copy here of it somewhere.
Yeah, it's an email from Stefan Casella, who I believe was an assistant U.S. attorney at the time. And there's an email below it from David Watt, who was Mr. Sauer's attorney, who says that I think we can still wrap this up before you leave on your trip. My client is still troubled by the, quote, acknowledged language, referring to some language in the proposed settlement, since he believes that he is admitting that there was reasonable cause to seize the money. In the meantime, I've obtained the settlement in the Taylor Produce case, which is attached, and it's very similar to Sower's case, and there's no such language in that settlement. So he says, we'd be satisfied with the exact same language from the Taylor case. Why can't we just do what was done in the Taylor case? And Mr. Casella's response to that is, Mr. Taylor did not give an interview to the press.
I'd ask unanimous consent to insert that in the record, and could you provide that to the committee?
Yes.
Mr. Johnson, just quickly, could you give us, I know that your client, Mark Zanuski in Michigan, had an experience. Can you just give us a nutshell, basically what his journey was, quickly?
Absolutely. It's truly shocking what happened to him. He had about $30,000 seized by the IRS. He owns a service station in Michigan. The IRS seized his money because he was depositing it under $10,000, because he simply would deposit whenever he got up to an amount that he thought was enough cash to deposit. Sometimes he would deposit under, sometimes it was over $10,000. The IRS takes his money. He says to them, I have vendors who are going to be taking money out of my bank account. What do I do to prevent the checks from cashing? They said, well, it's not really our problem, but we're not closing the account. If you want to keep using it, that's fine. So he says, okay, well, I'm going to put more money. And they say, okay, that's fine. So he goes to his sister-in-law. He gets a $10,000 loan from his sister-in-law. He also deposits credit card receipts into the accounts, money that is not even cash receipts. He deposits this into the accounts, but another $30,000. The IRS then comes back and seizes that money as well. And what they said to him was, now that we have all of this money, we'd be happy to agree to a settlement agreement under which we'll return the money that we seized the second time if you let us keep the money that we seized the first time.
So they're basically saying, hey, you messed up. You trusted us.
Right. And we're going to leverage that to make you settle.
And the same thing happened to you, Mr. Sowers, wasn't that right? The $62,000 and then the subsequent $5,000?
Yes, and that account had stuff coming off of it, and the bank, was sending me letters saying, or calling me and say, well, look, this thing's needs money put in it. And he said, well, you know what happened. You all know what happened, but it didn't seem like anybody in PNC Bank knew what had happened, and I never did find out from PNC. And they finally closed the account on their own, not because I wanted it closed, but they did. They closed it. So we had to transfer all that stuff to other accounts. But.
Well, I want to thank our second panel. For those of you who have walked this journey, we're very regretful that we've had to have this hearing, but we're glad that we have a forum that we can tell this type of story. It's this committee's job on a bipartisan basis to expose abuse of the federal government. When the federal government abuses its citizens, that is the interest of this subcommittee in particular. And you have our commitment on a bipartisan basis to do everything that we can to stand up for you. I'll note that everybody hates lawyers until they need lawyers. You know what I'm saying? But just saying. And there's a poignancy, and I just want to close with this. We've heard other witnesses in the past who have come in and have testified before the whole committee on similar situations, not with structuring, but where they've been abused. And I've been inspired by those witnesses. And we hear from a lot of people. We'll hear from think tank people, and we'll hear from professional people, and smart people, and this people, and that people. But what really gets my attention and inspires me is people who have kept faith in their country when they perceived that their country was not keeping faith with them. And that's what you've done. You've kept faith with your country because you realized this isn't the way this is supposed to be. This isn't why I was deployed. This isn't what I was standing up for. This isn't, the hard work of putting together a family business. This isn't working with my wife and creating this business over a period of time. It's not supposed to be this way. And you were faithful. And now what is happening is your country is kind of trying to come over the hilltop and try to rescue you and be a part of fixing this. So your willingness to stand up, your willingness to be sophisticated and smart about how you've done it, and your willingness to share with us your story means now you're handing something off to us. And that responsibility is not lost on any member of this committee. And so you have, I know I speak for my friend, the ranking member, Mr. Lewis, you have our assurance that we're going to do everything that we can to make sure that this is something that, that we put a stop to, and that the Internal Revenue Service recognizes that it is a creature of Congress, and it is responsible to the American public, The public delegates their authority to us, and then we delegate the authority to the IRS, and if they're operating outside of that delegated authority, they're going to deal with it. So thank you all, and members are reminded that they have the requisite period of time to supplement the record today. And with that, the committee is adjourned.
Thank you, sir. Thank you.